The following program is not a safe space. There are no kittens here. We will not be giving out cookies. The opinions expressed herein have taken a life form of their own, and they can be quite merciless. Deal with it, Mary. Everybody, welcome to the fun program. I'm your host, Joe Neerman, aka Good Lawgic. I need to start off by asking you if my audio is good here. If my audio is good, you might notice background here, like the good old days. Thank God. Is my audio good? That's what I need to ask. I'm gonna have to check. I don't trust. Let me see how good this is. I guess I'm gonna have to hear myself. Let me just hear myself. Oh, it's good. Oh, it's good. Oh, it's so good. Oh, wow. I missed the sound of my voice. I don't get to hear myself nearly enough. Well, I hope you all had a great 48 hours since we last saw each other. I took a night off yesterday. Tonight is actually my anniversary. It's true. These are facts. Tonight is my anniversary. As it happens, we're in the process of moving from our summer place to our normal home, where I have my normal studio and I got my cool Good Logic background behind me, and everything feels right. Everything feels like where I always have been as far as growing this channel and wondering why things are on my shoulder. But it feels right here. It feels the whole environment affects your mood, affects everything. This just feels like my seat, which I need to get a new chair. But it just feels right when I'm here. It just feels right. And now I'm back. But whenever I move, I always worry that my computer will automatically reset my audio and not find my mic. And then I'm left like sitting there, and everyone's like, "It sounds like you're in an alley, Joe. Why does it sound so bad?" But now it's good. Okay. I sorted all that stuff out. I want to apologize to those of you who are on locals. And normally, whenever I make an appearance somewhere, I always will notify you on locals. And I made an appearance just like a half hour ago, less than that. And I did not notify you all because I knew I was going to be in there for 5 minutes, and I didn't really have time. It was just sort of like bam, bam, bam. Like I saw that Nate and Kurt were streaming, talking about this topic that I plan on covering tonight. Specifically, they were talking about Robert Barnes' take of Nick Rekieta's motion, and they were not impressed with Barnes' take, and they were attacking him pretty aggressively on that. And that's not really where I was planning on going. We may end up going there before everything is said and done. But I will tell you. Oh, thank you. No, I'm not. I don't, John. I'm not hearing any problems. I just know historically there just have been. You want me to up the audio a tad? Is that what you want me to? Really? Just a tad? I can do that. I can up the audio a tad. Just a tad. Okay. We're good? We're good? It's low? What? Now I gotta check again. Hear my voice again. All right, I think I'm good. I'm okay with it. Okay. Okay, where was we? Yeah. So I had a few things I wanted to cover with you guys. While we're giving people a chance to sort of settle on in here, while I'm giving them that opportunity, I had an interesting thing that happened to me today that I was like, I need to record this while it's happening. I need to record this. So I'm going to share it with you. How do I can I download this? Download it. I sent it to myself. I never downloaded it onto this computer. It'll work better if I just download it. Okay. So this was earlier tonight. I had a poll. A poll was sent to me, and I was like, I wonder what they're going to ask me in this poll. And as soon as it felt like it was political, I was like, I want to record my answers to this and share with you all just the nature of the questions that you get in a poll, which to me, I feel like a poll can actually push you a certain way. The way they frame things, I was like, and so I want to share with you because I thought it was an interesting thing. This was a poll that just came up at my phone randomly, and I actually just recorded my answers. You're not going to hear anything. You're just going to see me or the results of me touching my screen. So, without further ado, because there's been too much ado already. All right, so this was you're looking now at my phone, my own recording on my own phone. So this is the questions that they gave me. They want to know what state I was coming from first. I can never find New Jersey. All right, there you go. Describe yourself as a man or a woman. Man, woman, another. I thought that was funny. I thought that was really funny. Yeah. Yeah, I went with man. And I kept being torn. Should I give them what I want, what's truth, or should I give them like what I think they want? I put in my year of birth. They want to know last year of schooling. Let me play this a little faster. All right. Speed the suck. Speed this sucker up. Oh yes, yeah, so they wanted to know my religion. I told them I was Jewish. And apparently that put me into this set. I said, generally speaking, do you think yourself as? So I told them I was Orthodox, and here I was torn. Do I want to think of myself as a Republican? Do I think of myself as other? Not sure. I don't like a lot of Republican policies. I don't know. I was very torn here. You see me dithering here. That's what you're seeing happen here. Me not being undecided. Undecided. Am I Republican? Not sure. I don't know. All right. Definitely closer to the Republican Party. Definitely closer to that than Democrat. Political terms, yeah, I'm going to go conservative there. Let's put down conservative. I was like, do I want to say conservative? Yeah, I think I'm good with saying conservative. Why is it taking so long? What happened? I think I wasn't sure. Please rate your level of motivation to vote in November election on a scale of 0 to 10. Yeah, I'm very motivated. I'm very motivated. All right. Below is a list of issues facing our country. Please indicate which two of the following are the most important issues to you when you read. You still complain about my low volume. I'll turn up my volume a little bit here. All right, I turned up my volume. All right, so I gave them inflation and immigration being the two. And I was unsure. Do I want to say I'm going to vote for Trump? Yeah, I want to say that. How certain are you going to vote? Are you really sure? Are you really sure you're going to be voting for him? I was like, I'm somewhat certain. All right. Please rate your feelings towards some people with 100 meaning very warm, 0 meaning very cold. So Biden, I don't really like very much. I was like, wait. I put Trump only at 70. Did I go higher? I think I went higher. I went higher in the end. I was like, I'm feeling good about him. I gave Biden a 3. I was like, he hasn't gone on a mass murder rampage. I thought 88, 89 was a good number for Trump because he's very solid, very solid. I was like, I don't know what they want. I was like, I don't know what they want. Netanyahu, he's okay. He's all right. He's okay. Move along. Kamala Harris, you suck. I don't know why I gave her as much as a 4. JD Vance, I'm overall pretty good. Pretty good with him. Republican Party, eh, 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 eh. The Republican Party, eh, eh. We'll give him a 4. Okay, Democratic Party is 0, and Tim Walz 3. Dude, approve or disapprove the way Joe Biden is handling his job as president. This is the part I wanted to get to. I don't go through the whole thing here. I couldn't believe when they went through their arguments. This is the part that I really want to focus on, and we'll move forward into a couple of other things. Kamala Harris said that she has always been a staunch supporter of Israel. The first resolution she ever sponsored in the Senate was to combat anti-Israel bias in the United Nations, and she's been unflinching in her support for Israel and condemnation of anti-Semitism. Lies, 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 lies. Absolute lies. I was like, are you kidding me? As vice president, she has steadfastly supported efforts to provide Israel with aid so that it can protect its people and prevent October 7th from happening once again. No, no, no. When you start taking the position you're taking, you're begging for October 7th to happen again because you're too stupid to know it or you don't care. Donald Trump promotes white nationalists and uses Nazi imagery and rhetoric in his campaign and has said that Jewish Democrats hate Israel and their religion, which is true. Most of them, they really do. The vast majority. Vast majority. They hate Israel and they hate their religion, the Democratic Jews. We need a president like Kamala Harris who stands with Jews, not one who stokes hate and anti-Semitism. What a ridiculous, complete pile of crap. This is where I was like, okay, this was put out by Democrats. This was totally put out by Democrats. This is utter, utter lies. Unbelievable. I did raise the volume. You told me he's going to... What? What? Donald Trump says as president, he was Israel's strongest supporter, which is true. He really was. He moved the U.S. Embassy to Jerusalem, mediated the Abraham Accords, becoming the first president in 25 years to help Israel open diplomatic relations with a new Arab country. Kamala Harris is a radical who's catering to left-wing anti-Israel protesters and did not choose Pennsylvania Governor Josh Shapiro as her running mate because he's a strong supporter of Israel. And Donald Trump will reverse the Biden-Harris policies that create massive inflation and illegal immigration, and he will be a strong leader who ensures Israel gets the weapons it needs to finish the war and defend the people of Israel. Now that you have more information, thinking again, if the election president were held today, just between the following candidates, who would you vote for? So, yeah. Anyway, I thought that I was like, this is the way they do these polls is so. It's like I was sitting there the whole time. I was like, I don't know if they're trying to like play with my brain here. I felt as if I was like battling. I was like, I'm being assessed here. I'm going to be thrown into. I'm being compartmentalized in ways I don't want to be compartmentalized. I don't like being compartmentalized. Now you tell me to use my inside voice. I can't. Are you guys trolling me? Are you trolling me? Is that what's happening here? Before I was too low. Now I'm too loud. I'm being trolled here. Look at this. I'm getting audio too low. Joe, it's late. Use your inside voice. This is literally both written at 10:17. You guys are so mean to me. I think it's fine also. All right. I want to get in on the whole Nick Rekieta assessment from Uncivil. There's one.
He did make an interesting revelation.
There's one thing that Megyn Kelly covered that I just wanted to sort of really disagree with. Really, really disagree with something that one of her guests said, which I was like, no, this is stupid. This is stupid. This is a bad, bad call. I hope this person is not advising Donald Trump. Let me share with you what it is that I was looking at. Push polls are not just to get your opinion, but to push you to the position they want. Also, you're on a laptop. No, I'm not on the lap. No, I'm not. I'm not on that mic. I actually tested out the mic for a long time. I tested and tested and tested. So no, I'm not. I'm not on the laptop. I'm not on the hard drive mic. I'm on this. I actually went like I started going like this to see if the audio would pick up, and it did. So stop messing with me. Stop messing with me. So this was Megyn Kelly, and while I actually pulled that up, I don't know what it is that just reminded me. On locals, some of you who are joining me in fantasy football, I put up a poll on the date that when we should have it because I can't do it on Sunday like we said. So I'm looking at either Monday or Tuesday. I had 2 people. I only want people to vote if I listed them off by name. But although it looks like I have 1 extra opening, so if you're interested in joining, it's a $100 sign up fee. It's the poll. The thing is likely to be on Tuesday. It's Fantasy Football League, which I'm going to be participating in with the other people on locals. It's a goodlogic.locals.com if you're interested in signing up. And it's going to be. I'm looking for that to be Tuesday at 7 p.m. is when that thing is going to happen. Anyway, where was we? All right, so I wanted to cover Megyn Kelly here because they're talking here about the debate that he's planning on having with Kamala. The debate with Kamala. And this is what they're addressing. Listen to the insight they give.
Stu, in his interview with Sean Ryan, who we love, Navy SEAL, was on the show over Memorial Day. And he revealed, I think for the first time, something interesting about a deal term Joe Biden wanted before that CNN debate in which he wound up, tanking his own chances at a second term. Take a listen to this clip.
I gave up everything. I said, they gave me a thing.
Oh.
They really didn't want to debate. They gave me CNN. They gave me Dana Bash. They gave me, who's, not exactly my best friend. And they gave me what I used to call fake Tapper, but I don't call them fake anymore because I thought they were very fair. Both of them were very fair during the debate. But they gave me 2 people that I would never take. They gave me a network that I would never take, a cable station, CNN. They said, we'd like you will both sit down. I said, look, let's stand up, okay? I was able, that's the only point I got. And they gave me all of these, they said there's no audience. I'd rather have an audience, but they say there's no audience. And they said, we're gonna cut your mic off after your question. So they gave me everything. And they thought I'd reject it. I said, I'll take it because it was the only way I could debate him. And they were surprised I took it. But they sort of had to go forward with it, and we went forward. And I wouldn't say he performed brilliantly. This was not when.
So Joe wanted to sit down. He doesn't want him sitting down. They want notes. He's like, no notes. The only thing he got was him standing up.
Winston Churchill, and he was very white. He wore very white makeup. I don't know what happened to him. I don't think his makeup artist did a great job. Actually, I walked in. I said, "Man, is he white?"
What was interesting, though, is that there was a proposal at one point to have the 2 of them sitting down. And he wasn't totally clear. I'm almost sure that came from Team Biden because all those other terms came from Team Biden. But whether it came from Biden or CNN, it's kind of same difference. Somebody was trying to help Biden out, realizing the likelihood of him not being able to stand for 90 minutes was higher than normal, higher than average. And it was the only thing he pushed back on. And it's amazing, right? After all that now Kamala Harris comes back and says she needs to sit too. And she needs to have her little notepad with her sent out there with her cheat sheet because the test is always easier to take, Stu, when it's open book.
Yeah, or with someone like Donna Brazile is.
Yeah, so that to me is a no-fly zone. And you're going to see over here.
Leaking you the questions in advance. It gets very easy as well.
Spend some time.
Can we just spend a minute on that? How is this woman employed by a news network still? How does Donna Brazile have a job with the network? She cheated on a presidential debate. She took the questions from CNN and she gave them to Hillary Clinton and her team. And she got hired by Fox after that. And now she's hired by ABC. And now ABC has the next presidential debate.
It's incomprehensible that that happened. And, it's funny to look back at the history of this, where you have a situation with the debate where, you go back to the 2020. I mean, Biden was elected basically with this idea of return to normalcy. Now, that was a nonsensical idea from the beginning, but that's basically his pitch to people. Like, Trump, it's been intense. It's been chaotic. All this crazy stuff has happened. I'll bring it back to normal. Don't worry about it. And of course, when you look at the debate situation, the norms were set for many, many years. The Presidential Debate Commission put these things together. There was usually 3 of them. Sometimes there was 2. Usually there was 3 of them. And Biden is the one that overturned all of that. Biden is the one who brought it out of that system. Biden is the one that decided to do the debates the way that they were. These 2, kind of one in June. I mean, it's totally out of the normal schedule. Obviously, that blew up in his face. I think Trump is right that they didn't expect him to agree to the terms because they made the terms so difficult for Trump. But I think Trump's response was correct in that moment, where he said, "You know what? Screw it. I'll do it. I'm in. Whatever you want. I'm there. We will talk about it." I think his response should be kind of the same. I think, you guys are right. He's totally morally justified to just say, no, you're changing the rules. This is ridiculous. It's an unfair. That's all fair. But I think it actually benefits him.
It did benefit him. And the rules they gave him ended up benefiting him. That's for sure. I mean, I think that you're kind of ridiculous if you don't. I think that you're kind of ridiculous if you don't. If you don't think that it benefits
these things to happen, I think he should accept them and give it as open an invitation as he can possibly muster to her to make more of these things happen. Because the more time she's in front of the American people, the better the results.
This is
not to mention adversarial media.
This is what he just said. Now is the part I took issue with. Let's go back a little bit. This part right here. This part is where I'm like, you're out of your mind. This is the worst idea in the world.
Actually benefits him for these things to happen. I think he should accept them and give it as open an invitation as he can possibly muster.
No. Terrible idea. Stupid. Idiotic. Stupid.
To her to make more of these things happen, because the more time she's in front of the American people, the better the results.
Wrong. Because if you allow her to go in there with notes, do you think she's going to come in there with a little trapper keeper and a notebook? That's not what's going to happen. We all know that's not what's going to happen. If you allow her to go in there with her quote unquote notes, her notes end up becoming notes together with a little Facebook Messenger chat or Skype messaging or whatever that she's communicating with people who will be giving her responses to every time she gets blown up and confused by Trump. She'll be bailed out by somebody sitting backstage with the Wizard of Oz and basically sitting there typing out, "Oh, tell him what about this?" Blah, 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 and giving her cue cards to help repair her stupidity. And if she's sitting there, and don't underestimate her, do not underestimate her. If you allow her to sit there as some sort of newscaster who's basically reading her notes, which is actually going to be a tablet, and that tablet is going to have someone communicating with her, he's not going to blow her up. He's not going to destroy her, because it's going to be Donald Trump by himself against her and her entire team sitting there on the debate stage with her being the stupid puppet saying the words that she's told to say. And the American public who's watching it is going to think it's actually her own brain that's coming up with these answers. So she's not going to look bad. She will look much better than she ever possibly should, because someone else will be moving her mouth for her. So no, you do not agree to the notes. It's not worth it. It is much better for them to never, ever have a debate, and for the entire world to keep mocking what a complete and total moron she is, how she has no policies, and whatever stupid policies she gives, even the left says, that's crazy. What are you thinking? Why are you copying Trump? What's with this new communist price gouging idiocy? Let everyone keep going with that messaging. You don't need to give her an opportunity to look like she and pretend that she's on equal footing with Donald Trump in her ability to debate, because she's sitting there with puppet masters behind her moving her mouth for her. She'll literally, it's not literally, she'll have someone sticking their hand basically up up her gut and controlling her mouth for her by printing out for her what the hell she should be saying. So she's not going to look terrible. And she's going to falsely be able to deceive the public into thinking that she knows what she's talking about, even though she clearly does not. So we're much better off with them never having a debate and the public getting an accurate assessment of her utter incompetence by not allowing someone to spoon feed the answers to her live on stage. And that, because that's what will happen. That is precisely what will happen. So I think that this guy who said this is crazy. I don't know who he is. I don't know anything about him, but I'll tell you, Stu Bergier, whatever. I don't know if that's him or the other guy. Who is it? Stu Bergier and Stephen Miller. I don't know if that's Miller or Bergier, but that's or Berguire. I don't even know how to pronounce his name. But whatever it is, this guy here in the middle, no, he doesn't know what the hell he's talking about. He's wrong. That would be disaster for Trump to make her actually look like she knows what she's talking about because she's being spoon-fed. Terrible idea. Never want to see that. God. Awful. He's on Glenn Beck's show every day. Well, I'm sorry, he's an idiot. At least on this particular issue. I don't know what else he said in the past, but that was very unimpressive. Very unimpressive. All right. Let's get in on Nick Rekieta. Let's get it started. I got some amusing things I want to share with you after I finish doing the assessment or rebuttal of Uncivil Law. So a few things that I need to get out of the way. Nick Rekieta is obviously a friend of mine. I'm not going to be giving you any, while I do have factual information that others do not have, there's zero chance I'm going to be revealing any of that to you or to anyone, because anything that was said to me along those lines was said to me as potential counsel for Nick Rekieta. So I do have some background about things that happen procedurally, which I'm not. So I sort of feel as if I'm coming with this with a little more knowledge as to where everyone's coming from than most people. And I'm not saying that that doesn't make me cool or anything like that. It just makes me like a little bit more frustrated because sometimes you're kind of hamstrung. But I'm also, and I'm going to assess when I'm coming here. I wanted to get that out there on the table for anyone who doesn't know me or hasn't seen me yet with Nick, doesn't know me a long time. So that's out there on the table that I am friends with Nick. When I'm doing this assessment, I'm trying to do a legal assessment purely based on what the law says and how sound or unsound a particular legal argument is. And if it's sound, great. And if it's not sound, them's the breaks. I also am friends with Uncivil Law. I have deep respect for both of these gentlemen. I know Uncivil likes Nick Rekieta as well. Nick Rekieta is facing 3 different charges related to a search and seizure warrant that was issued, where there was a warrant issued by the police to go into his house and search for drugs. And during the course of that warrant, they ended up seizing what the police claim was 26 grams of drugs, which makes it a relatively serious offense once you cross over that 25 threshold. And additionally, they charged him with possessing firearms while having cocaine, and also neglect of children. His kids had actually been taken away from him by the state back in May when the arrest first happened. He has recently gotten them back. So they are in his custody presently and have been for the last couple of weeks. Last week, Nick Rekieta, through his counsel, filed an omnibus motion to try and get the case dismissed and or suppress certain evidence, specifically evidence related to testimony from an individual who is a friend of theirs, and some would say very, very close friend of Nick and his wife Kayla, who was arrested as well, facing similar charges, and that she initially had been arrested, and then she was released, and then there were new charges dropped against her. Anyway, Nick filed this omnibus motion. There were 3 different grounds that he had for this dismissal that he was arguing for. Actually, 2 different grounds for dismissal. One related to suppression, and we're going to go through the different. We're going to be going through in this video here. Kurt, which is Uncivil Law, is breaking down for us oral arguments. There's a transcript of oral arguments that were made. At the conclusion of oral arguments, the court ended up adjourning, allowing the state to have time to put their arguments in writing, and gave Nick time to reply. And Kurt is weighing the oral arguments. And Kurt is not a fan of this motion. And he likes Nick. He definitely is. He and Nick are friends. We'll talk about various things that Kurt makes comments about, their relationship, which come up during the course of the stream. I have gone through this stream and seen what Kurt says. Some of the things that we're going to see Kurt say, I agree with. Some of the stuff that he says, I disagree with. But I thought there was enough here that I disagreed with that I was like, I really want to rebut some of this, because I think that from the legal arguments that he makes, some of them, I was like, that's not accurate. I don't agree with that at all. 1 or 2 in particular. Let me cover a couple of these super chats. We'll jump on in. Interview guests invite Harris' biggest weakness is when she opens her mouth. She's completely unable to speak. I think her point was to get her in front of camera as often as possible. His point was to get her. That's not what he was like. Get in a debate any way you want, any way you can. I think getting her a debate where she can falsely give the appearance of knowing what she's talking about is counterproductive. You're setting the stage to make her look good. And I don't think that's helpful. Interviews, fine. The point is, force her to answer for herself. Never give her an opportunity where she can look like she's answering from her own brain, and really it's someone else who's answering for her. That's my whole point. Kamala Sutra probably has plenty of hands up her. Fair enough, Jaretard. Let's get into it here. This is my good friend Uncivil Law. Let's break it down.
Well, hello, everyone, and welcome to Uncivil Law, where, as always, we learn through the misfortunes of others. For today's stream, we turn our attention to the recent omnibus hearing, which just means we're going to discuss
Before we get into this, let me just cover a couple of rants here. Denise says, happy anniversary. Thank you. Also, thank you so much for going on early. I always fall asleep in 30 minutes. You're going live, then I have to rewatch in the morning. Ginger Ninja says, this is the most exciting live stream Tyler's seen in a while. Looking forward to analysis. As a wise man once said, I sim for the Constitution. Robert Barnes. Yep. There you go. All right. I sim for the Constitution too. Let's go.
Things. In the case of the state of Minnesota versus Nicholas Rekieta, primarily we are looking to dismiss and suppress. We are not happy with the search warrant. We're not happy with the evidence against us getting that search warrant.
Yep.
We're not happy with the amount of it nor the quality of it.
Yep.
Quality nor quantity is sufficient.
Yep.
We are concerned the search was improper, illegal, or otherwise problematic in some way.
That's what Nick contends.
As we learned from the motion itself relating to this, as Nick filed his motion, Nick basically said a couple things. First of all, he said one of the people had a serious grudge against me, and that should have been disclosed. Another thing he said is that they didn't view the original video because I hid it. I mean,
so, and he's referring specifically to Aaron Imholt, who is certainly seems like he's one of the sources that the police relied upon in order to secure their search warrant. And Nick says that is an argument he makes, that they didn't properly disclose that he is not a quote unquote concerned citizen. A concerned citizen is a term of art which is designed to say he's a disinterested party who's coming in here looking out and offering a tip to the police just out of concern for the well-being of the community. Well, if someone has a great deal of animus, in that case, they're not able to qualify as a concerned citizen. You can't just rely on the gossip of an enemy. You know, imagine the person who hates you most going to the police and talking to them about you. So you might say, yeah, I don't know, we really should just have that standing on its own without further corroboration be justifying a search warrant.
Made it private. Didn't delete it, didn't remove it, mind you. Might have made it private.
He did.
Okay, so they didn't view the original. So they
We know he did because that's what Nick says in his legal argument, in his motion. He said that he made the video, and the specific video they're talking about, I believe, is on May 21st. It might have been 22nd. I think 21st. May 21st. That I believe that was. I know the stream. I know on the stream, Nick was breaking down a motion that he lost in a lawsuit that he has against Montegraph, which is, I think his real name is Steve Quest. Montegraph is suing him for defamation. He was looking to get it dismissed, and he got a decision denying his application. And Nick was streaming, breaking that down that night, and he didn't look good. He did not look good that night. Anyone who knows him, anyone doesn't know him, he didn't look good.
they're suspect. In fact, the video has a watermark on it that shouldn't have been there or wasn't there in the original. So the quality of the evidence is not necessarily great, according to Nicholas. Now, I will note, as I've noted before, that the standard here, of course, is probable cause, which is exceptionally low. You know, on a scale of 1 to 10, if 9.5 or 9.9 is beyond a reasonable doubt, and 5, by definition, would have to be preponderance of the evidence, well, it has to be less than 5 by definition. So what is it? Well, maybe 1 out of 10. Maybe it's that low. Obviously, you could quibble with the number, but the idea is more important than the actual number. But we understand what we're talking about, right?
This is where I'm going to take my first issue with Kurt. Now, I don't know about, the scale is subjective when you want to refer to a scale of 1 to 10. But when he says that probable cause is all the way down at 1, I have to take issue with that. If anything, I think one can make a stronger argument that it's 5 than that it's 1. And this is a significant factor throughout the course of this video. He comes back to this claim that he makes at the outset repeatedly during the course of this video. And as much as I like and admire and respect Kurt as both content creator and a very intelligent attorney, I think that he's grossly mistaken on this part here, where he's painting probable cause as if probable cause is a nothing hurdle. It's a nothing thing. It's not possible cause. It's probable cause. Means we have to think the guy's probably committed a crime. Now, the yardsticks that you can use to get there are far lower than you would the yardsticks for evidence that would be submitted at trial. And he's going to talk about this during the course of the stream. And in that sense, I 100% agree with Kurt that you can get to that number, whatever that number is, whether it's above 5 or not, I don't know. It's definitely not way down at 1, and I can prove it. The way I can prove it is there's a case called Terry v. Ohio, which I know Kurt is familiar with. Terry v. Ohio is a fascinating case which introduced a new concept into the law. This happened this decision came from the Supreme Court in 1963. In Terry v. Ohio, you had a situation. Let me tell you a quick story here about Terry v. Ohio, only because I researched this earlier today. So there's an officer there who had been working his beat for 35 years. He's a detective. And the law at that time in the early 60s was you cannot detain someone at all for even a moment unless you have probable cause. You need probable cause to detain someone in 1960 United States of America. Well, this guy here, what happened was this police officer sees 3 guys. He's walking the beat, and I think he might have been plainclothes at the time, but he sees 3 guys huddled together. One of them being this defendant, Terry. His name was John Terry. So he sees these 3 guys talking together, and he sees one of them break off from the pack, walk past the store, stop, look in at the store, and then continue past the store. And then a minute later, another one of the guys walks up to the same store, looks in the window, looks around, and then walks onward. And then the third guy does the exact same thing, walks past the store and looks inside there and just sort of like, and then they converge yet again afterwards, right? So they're all together. They go one by one, look inside the window, like they're trying to see what's going on inside the store. And then they're doing that individually. And then the next thing you know, they're converging. And according to the officer who arrested them, he said they did that 4 or 5 times, where they each keep walking past this store and he sees them individually, never as a group, but individually. Each of them keep looking in the window as if they're casing the joint. And he said, in his estimation, he saw their conduct and recognized that this looks like people who are going to be looking to rob the store. So he went over and detained them. And he ends up engaging in a search. He ends up detaining them actually inside the store. And he finds that 2 of them have a gun. And he ends up arresting them, and they end up getting arrested and convicted for carrying a concealed weapon. Well, Terry comes along through his counsel, and he says, look, you didn't have probable cause. Without probable cause, you cannot, it's an unlawful detention, which is essentially an arrest. If you're not free to go, that detention is from the eyes of the law in 1963, that was considered like arresting them. And as a consequence of that, since you didn't have enough there to establish probable cause, you therefore now were not able to frisk them and find the guns, and he could not be charged and or convicted, and accordingly he should be released. The Supreme Court introduced a new concept in Terry v. Ohio. What they came out with was that lower than probable cause is a concept of reasonable suspicion. What is reasonable suspicion? Well, reasonable suspicion entitles you to is a key card that enables you to actually investigate further and start infringing on someone's rights. How do you get to reasonable suspicion? Well, Supreme Court explained it cannot be just a hunch. There has to be articulable facts that you see, and you're looking at this person, you think that they're committing a crime or about to commit a crime, and that they are, and you need to be able to spell out, this is what they did, which based on my history leads me to believe that they're about to commit a crime. Accordingly, I detain them. Once I detain them, and because you can't just stop someone and frisk them. New York had a whole thing about their stop and frisk laws that happened under Mayor Bloomberg. You cannot just stop someone and frisk them. You need to have you don't need to reach the higher level of probable cause. You need to get to this level of reasonable suspicion. Okay? And you need to be able to spell out what those facts were. I watched a video which was trying to articulate the distinction between reasonable suspicion and probable cause. And what they basically pointed out was, let's say a guy comes home and he's 10 minutes late, and his wife is like, you're 10 minutes late. Obviously, you were cheating on me. That's not reasonable suspicion. But if he comes back home and he's looking at his phone and laughing, and then she walks in and he starts hiding the phone and she smells perfume on him, well, now you start having now you might be at a level of reasonable suspicion. You can be like, there's something funky going on here. You're trying to hide your activity. I smell some woman. It smells like some woman's on you. There's some lipstick on your shirt. That is now reasonable suspicion. You get, if she sees him sitting in a restaurant with someone, now, with some woman who's all dolled up and is sitting there, and she's reaching across and touching his arm, now you might have probable cause. But probable cause is definitely higher than reasonable suspicion. Because probable cause, like I said, it's not possible cause. It's probable. Which to me, if you had to ask me what that means, I would say it's more likely than not that the person committed the crime. It is a preponderance standard. It is a 5. Now, is that the law? Am I telling you that's the law? No. because I think that's very subjective. And we look at the totality of circumstances and think, do we think this person is probably committing a crime? To me, that's preponderance of evidence. That's more likely than not the person is committing a crime. The thing about probable cause is you can get there without having very hardcore evidence. In fact, invariably, it almost always relies on circumstantial evidence. It'll rely on something that, you overhear something, or you see something, or someone tells you something. There's some gossip that comes in here. Hearsay is completely permissible in order to reach that 50% yardstick. It would not be admissible at trial. You wouldn't be able to use that at trial, but just to get to the status of probable cause, you could rely on hearsay, things that are completely inadmissible in court. But for Kurt to come along and start portraying that probable cause is, it's no biggie. That's no biggie. Respectfully, you're spitting this perspective. And I'm not saying he's spitting on it, but I'm saying is that people who embrace this perspective are too easily spitting on our constitutionally protected rights, our rights not to be, because all the time anyone could just say, this person looks guilty to me. My hunch says that this person's guilty. A hunch that someone's guilty is not even enough for reasonable suspicion, which is lower than probable cause. So I would say a 1 is a hunch. A 2 or 3 is reasonable suspicion. And probable cause all the way up at 4 or 5. It's not a very, very low joke yardstick to reach, that anytime the person sees something, I see this guy who's got track marks in his arm, he must be drug addict. That's, someone told me it's track marks in his arm. That's not probable cause. Now, I do want to agree with something that he's going to say later that many of you are probably screaming about. Some of you who are, especially some of the people who are haters, I'm sure there's more than a handful in the crowd there, and you're more than welcome here. You're going to say, well, it's not just this. You have the video, and you have the complaints of the pastor, and you have this, and you have that. 100%. 110%, those points are all accurate. Every point about that is accurate because we do look at the totality of circumstances. Totality of circumstances is very, very important. And you cannot look at one in isolation. We have to look at the big picture. That's what the Supreme Court tells us to. Look at the big picture here, see if we get to probable cause. However, to the extent there's a flaw in pieces of evidence that are coming in, that's why it's important for the presenting officer to say, here's a piece of evidence, but the court should be aware that this piece of evidence has a flaw in it. Because that's how you get to having a totality of circumstances. Now, we understand that an officer seeking a warrant is going to be leaning against the defendant because they're coming here saying, I want to get a warrant. I think this person's doing a crime. So you sort of know where they're coming from out of the gate. And you would think that an intelligent judge, which we hope most of our judges are intelligent, would recognize that this is probably going to be slanted against the defendant. So a judge who's sitting there and looking at it fairly probably would say, okay, he's phrasing it this way. He's probably being a little bit generous or being a little bit, half glass empty as far as looking at it in the defendant's favor, right? He's going to be tilting against the defendant. So I sort of need to sort of read that into this report. But if the officer leaves out facts that are material and important, and only presents the things that help him and leaves out the things that hurt his cause to get a search warrant, that starts getting you into like, look, that should have been part of the totality of circumstance equation that the judge had. And if the judge had that in his or her equation, in their calculus, they may not have signed off on the search warrant. So that's what we're breaking down over here. I saw there was a super chat that came in over here, a couple of them. Legal Vices, my man. How are you, brother? Good to see you. Terry V. Ohio, stop. Yeah, I see what you did there. Very clever. Very clever. Go for big guy. You are correct. Probable cause about a 5 on a scale of criminality. A 1 would be obscenitizing a broken window with no one around. Funny, I always thought Uncivil would be the joke / criminal of law too. Glad Rackets is doing better. Thank God he is looking like he's doing better. Do you believe that Nick needs help and is an addict? In denial. Why is he blocking the police video? Big fan, Joe, but Nick and his wife need help. Okay. I had a feeling someone was going to ask me this question. And it's a perfectly reasonable and logical question to be asking me. If you ask me about, I haven't spent a lot of time talking about the Nick Rekieta situation. I talked a couple of times when it first happened. I haven't addressed it until in the last, I don't know, anytime this summer. So I'll tell you this. I think when people look at Nick Rekieta, I think that there's a lot of things that go into their calculus in assessing him as a person going off a cliff or whatever it is, whose life is spinning out of control, and all these the other issues that they had with Nick, which ended up developing a more significant percentage of people who were haters than a podcast like Nick would tend to have. And I think that people felt betrayed by him. They felt that he didn't live up to values that he espoused. I think people started hating on him a long time ago, like probably shortly after the Johnny Depp trial. At least a year and a half now, he's been facing like people who basically make a career out of coming after him. And I'm not looking to get into their motivations or where they're coming from, and I understand people can feel the way they're going to feel, and that's, Nick has to deal with that on his own. You ask me, did I see changes in Nick before May 20th of this year? I saw that the nature of his show was taking a slightly different direction. It's not my place to weigh in as to how someone is doing their show. I would be like a complete and total jerk to even express something that I saw it change. I was like, he's doing what he wants to do, and he's grown. Adults are able to make decisions. And if this is what's working for him, God bless. Let him enjoy. Have a good time. He's, that's totally up to him. When I hadn't been on his show very much, let's say during the 6 months prior, but I made my occasional appearances. I certainly was on there a couple times. He had been on my channel a few times as well. I'll tell you that a whole bunch of people asked me, and I've asked several people in his circle, why didn't you say something to Nick? And how could you be enabling him? And why are you letting him get away with this and act like, a crazy person, self-destructive and harmful to his family, and getting into the morality of his relationship with April, and, speculating about that, which I'm not into the whole hot tub streams and things like that. No one's ever seen me do anything like that. You're never going to see me do something like that. It's not the same show that I'm running over here. But, the people who have those questions, I'll tell you this. As far as Nick drinking, I always saw Nick drink. It's from the first time I met him. The first time I met him, he was drinking. To me, I never thought of the drinking as being an issue. The reason I never thought of it being an issue, and I still don't know that it ever was an issue, but the reason I never thought of being an issue is because I figured, he comes on stream, he has a drink, he raises a toast to someone. Guy is phenomenal at giving a good toast to people. And I was like, I don't know if there's anything wrong with that. It's certainly not my place to judge. I never for a second looked at him and was like, oh, this guy's an alcoholic. That never even crossed my mind. I still don't think he was. I still don't think he was an alcoholic, but to be fair, I don't know enough about alcoholism to say when someone crosses a threshold from being a casual user to being an alcoholic. But I have zero evidence currently to believe that he ever was an alcoholic. With respect to his drug use, assuming that he ever did use drugs, and off the record, not based on anything he's ever said to me, if you ask me, I would assume this guy's done drugs at some point in his life. And probably sometime within the last couple of years, not because of anything he's ever told me. I would just assume, good chance he has, So what I saw from him in that video is the first time that I saw what people would call warning signs of someone who's going in a self-destructive path. And I looked at it and I was like, this is when I saw it before he was arrested. I was like, that's not the Nick I know. It's not the Nick I know. And I had concerns from him. And several of us spoke about these concerns, what steps could be taken to assist him. And before any of those steps could actually be employed, guy's arrested. Going through the process that became public fodder. So I don't feel like regret that, like, oh, I should have stepped in there. And I was like, that was never the nature of my relationship with Nick. And I certainly didn't have anything that I look back on. I was like, wow, that was a warning sign there. So I think that at a certain point, like, you know, he may have done things that were not healthy for himself or his career. That's a personal opinion. You want my personal opinion on that? I think things didn't look good on that stream. They didn't look good in that stream. So I was like, you know what? I want to see what, and that's why before he was arrested, I was like, yeah, to the extent I can help this guy, he's an awesome guy. He's a brilliant guy. He's a genuinely good person. So if I can help him out, like, why wouldn't I? And that's what a lot of his friends said. And the next thing you know, he's arrested. So now he's facing these criminal charges. He's got all these criminal charges, and he's got, you know, whatever haters he had beforehand, the haters just start multiplying at that point, which is not surprising at all. And then especially when the children element comes into something like this. Because when someone is harming themselves, you might look down at them and say, like, you feel bad for them. If they're harming children, their own children, that's when it becomes a whole different ball of wax. Then instead of them being, you know, self-destructive, now you're being destructive towards innocent people who you're supposed to be taking care of. And I think that fueled a great deal of rage toward Nick Rekieta, where people were actually angry at him. How dare you do this? How dare you do this to your own children? You were the father figure, and you did this to your own children. I think that fueled a great deal of rage. And I said when I saw that, I don't believe the claims about, like, you know, the child abuse or neglect. No one ever said, God forbid, abuse in the sense of anything other than passive abuse via neglect. I've never heard anyone even pretend to make a claim of, you know, intentional abuse. But, you know, I'm definitely not giving a pass to neglect and passive abuse. I simply was of the opinion I didn't believe that there was passive abuse. And to this day, I don't think that there was passive abuse. I think that is, those claims are thoroughly empty. And I said a couple months ago what I say right now, which is, if in fact there was abuse, even if it was via passivity, via neglect, that's not excusable. That's not something to just be like, oh, you know, give him a pass, give him a break. No, that's completely inexcusable. And that changes the entire equation in my mind as well as everyone else's. But then I come to a point where I'm like, okay, so at what point do I accept that there was some sort of neglect here, or some sort of abuse, or some sort of, I don't mean, again, I don't want to imply physical abuse. I mean passive abuse that is, you know, the type that is associated with neglect. And in that scenario there, I don't believe there ever was. I don't buy it for a second. And if I did, well, in that case, I'd have a whole different view of things. So now I look at him today, and when I see him today, I see a guy who looks like completely different than what he looked like 3 months ago. In a positive way. In a very positive way. So I'm hopeful that he is someone who had a freaky, terrifying scare about, you know, his life basically being at a crossroads, and you either wake the hell up or you just completely self-implode. And if you ask me, it looks like he reached that crossroads, and thankfully he took the right path. And he looks a million times better today. I think you're crazy if you don't think he looks a million times better today than he did 3 months ago, 4 months ago, 6 months ago. He looks better than he looked 6 months ago. Not just that night in May. I'm talking about how he looked in February. He looks much healthier now. So, and it's not for me to deem whether or not he's living a good life. Who the hell am I? That's not my place. You ask me if someone asks me my opinion, all right, I look at someone, I sort of say, does someone look like they're on a healthy path? Someone look like they're not on a healthy path? I'd say to you, yeah, you know what? You asked me 3 months ago, I'd say this guy does not look like he's on a healthy path. You would ask me right now, I'd say, thankfully, he does look like he's on a healthy path. And I'm happy for him. And the most important reason is I'm happy for his kids, because his kids need a healthy father. That's what they need. And all these people who sit there and basically try and bash him and hope that, he basically spirals into and loses everything or gets felted or whatever terms they have, rooting for his demise or his failure. You clearly don't give the slightest damn about his kids. You'll stand on his kids in order to sort of create a moral high ground for yourself. Oh, I'm looking out for the kids. So if you're looking out for the kids, then you should be hoping for him to actually turn himself back into the Nick that everyone fell in love with. And that's the path he seems like he is to me. So now, but he's still facing these criminal charges. So I'm looking at these criminal charges and I say to myself, look, I definitely want his kids to be okay. I want him to be okay. I want Caleb to be okay. I want them to actually have a happy, healthy, great life. And now I'm sitting here and I'm looking at these charges and this omnibus motion and these different elements as far as him trying to fight this omnibus motion, these charges against him. And people are like, oh, people are sitting here. And I know that whatever position I take or anyone in LawTube would take, because this situation is so polarizing, this situation is makes a lot of people very passionate, either for Nick or against Nick. So if you're a podcaster who knows him and a lawyer and you're breaking down this situation, no matter which way you go, you're going to have a lot of people thinking that you're full of crap. And if you say something in Nick's favor, people will look at you like, oh, you're only saying that because you're his friend and you're just nose guarding or you're sweeping or whatever stupid thing they're going to say there. And if you say something against him, then you can be like, oh, you're trying to make money off of the grift by going after him. And, and that could be complete crap too. Maybe that's your genuine opinion. And frankly, I don't know that any of us has the capacity to actually divorce ourselves completely from the way we feel emotionally about someone. So I can't deny the fact that, as a friend, I'm going to be looking out for him. And the best I can be doing is to try my best to not have that affect my legal judgment and to be upfront with you as to, all right, this is a battle I'm going through as far as, trying to understand something and looking at it and trying to divorce the individual it's affecting from my legal assessment and try to look at it as if this was any other person on the planet. And I think that's how I had the best chance of reaching the best possible, the soundest legal conclusion that I can reach and giving to you the best product I possibly can, that's what our goal is here. I want to give you the soundest legal assessment I can possibly give you. So, but we have this dilemma, you and me. And when I say you and me, I mean you, the public, and me, the podcaster. But it's not just me individually, it's me and my fellow podcasters. Anyone who's in my shoes here, whether it's Uncivil Law, Nate the Lawyer, Robert Barnes, Viva Fry, Legal Mindset, potentially Criminal Sean, anyone who's talking about this case is going to have a bunch of people who will be mad at us for talking about this case and basically saying you're sweeping or you're grifting. And I cannot deny the fact that I encourage everyone to be cynical of anyone you're listening to here. So you should be asking that question to yourself when you watch me, when you watch Kurt, when you watch Vivo, when you watch Barnes, when you watch Legal Mindset, when you watch potentially Criminal Sean. You should be asking yourself that question. And I can't tell you other than this is what I feel makes sense with respect to myself, with respect to how you should interpret what I'm saying. But what I would say makes sense is something I would say makes sense in every scenario, which is, okay, we understand that every podcaster who's a friend of his, who's covering this, is going to have some potential bias. That bias might be in his favor because they like him, or it might be against him because there's a lot more money to be made if I came out here telling you that Nick Rekieta is scum. So if I came out here telling you that, I know that I would have people raining down super chats on me and saying like, yeah, he's a schmuck, and like basically cursing him out. I know I would have much more money raining down on me for that. So then the question comes out like, okay, so if I went down that road, is my assessment in that direction motivated by a desire for money? So you can be questioning the legitimacy of what I'm saying based on my relationship with Nick, that's tainting me, or you could say my relationship with money, or any podcaster's relationship with money and their hunger for money and channel growth and love and attention from people out there, that's what's motivating them to be completely full of crap. So all I can say to you with respect to that is this: when you're watching me, when you're watching any podcaster who you think on this story, they're not being truthful because they're motivated to lie to me and they're not being honest. And I question whether they're being honest. And you're trying to reach that assessment. Is the person who's talking to me right now being truthful to the best of their abilities, or are they full of crap because they have some sort of bias, either love of Nick or love of money? So if you're trying to make that assessment, all I would urge you to do is this: ask yourself this question. The type of assessment they're giving, the type of analysis they're giving, does this sound like it's consistent with the type of analysis that they have been giving me for the last 6 months, year, 2 years, 3 years, 5 years? The nature of how they look at things. Is this consistent or is it inconsistent? And if it's consistent, at least, maybe, hopefully, they're being honest with you. And if it's completely inconsistent and you're like, wait, why is it you've never actually taken this side on this issue before, but all of a sudden in this case you are, to me, that should raise your hackles as far as saying, I don't know, I don't think that I'm really getting the legitimate scoop here and that they're full of crap. And I think that that's the most logical way to try and break down as far as is someone. And maybe they might even realize it themselves. Maybe the podcast themselves is not like intentionally thinking like, oh yeah, I'm going to go get money, or oh yeah, I'm going to go protect Nick. It's a matter they don't realize their own bias. But at least if they're being consistent with their overall take on things, in this case, with the type of take that they've had on case after case after case after case after case, none of us started yesterday. So if they're being consistent, in that case, it's likely that they're being genuine with you. That doesn't mean they're right. We can any one of us be wrong in this particular scenario, but that's at least that the effort is there to be truthful. That to me, that's the. So yeah, when I come to you and I say to you, I don't trust the cops. That's something I've been saying for 3 years. Someone says to me, well, the police report says blah, 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 blah. I'm like, yeah, okay, fine. I don't really buy what the cops tell me. So. To me, I don't feel as if that's indicative of nose guarding. To me, it's like, when have you ever heard me say, oh yeah, the police report says that? It must be true. That must be gospel right there. Right there. Look, it's in the police report. It's in the police report. It has to be true. When have you ever heard me say that? So if I was saying that, to me, that would sound dishonest to me. I don't know. It's a fair question, Brian. There's a reasonable expectation of privacy in your home until state introduces in court. I find release of video inside home not needed. Many states require redactions of body cams inside homes. Yeah, I think that's actually true because it's afraid, especially if there are kids in the video. Like, you certainly there are sick people out there. So, yeah. Blitzen, hit me with the 10. God bless you. 10 good Lawgic memberships. God bless you, brother. Let me check out my rants before I get back into, make sure I didn't miss anything here. Are we good? We're good. Okay, let's get back into Kurt's assessment. And the point that I'm making is this: the reason I went off on this whole Terry v. Ohio thing, the reason I went off on this whole thing is I think that this nugget, which starts less than 2 minutes into the video, really, really draws Kurt towards a far harsher assessment of this motion than otherwise should have, because I don't think it's a 1. And yes, I do think that all sorts of evidence will come in to help support a claim of probable cause that definitely are not going to be admissible at trial. And that's fine. And that's normal. And that's the way it should be. And that's the way it should be in all cases. And in this case here, in justifying the police search of Nick Rekieta's home. That being said, it's not a reasonable suspicion. You got to get up to probable cause, which, as pointed out in Terry v. Ohio, it's not something that you just have right away. You don't have that right away. Now, someone can come and say, hey, that video, even if it's doctored or even if it's like whatever, that's enough for probable cause. And you can come to that. You can come to that conclusion, perhaps. But let's go forward.
Is just basically objective indicia that indicates that this person has committed a crime. And it doesn't necessarily have to be as solid in terms of the evidence that's required in order to do that. We can do hearsay. We can do hearsay upon hearsay.
True.
We can do that kind of thing because the quality of the evidence doesn't need to be high because the standard we're trying.
Oh, and I want to be specific since I am doing here a rebuttal of Kurt. I want to be specific here that I am positive. I know Kurt and I know Nick. I am positive that even though Kurt is basically doing pretty much a takedown on Nick's motion here, that this is not at all motivated as some sort of grift. So he's going to be very aggressive against this motion. I am positive that he's not doing it for grift, that he's doing it based on what his good faith analysis of the motion is, that he thinks motion's a dog. That's never going to work. And I'm telling you right now that's his conclusion that he draws as he's analyzing as best he can. I'm positive it's not out of grift. So no one should take anything I said that I was saying that anyone who's going against him is going for grift, because over here you have someone who's basically going after Nick's motion and saying this is a loser, and I'm positive that this is not at all for grift. That he's just telling you, I just don't like this motion. I think it sucks. I mean, he's entitled, but I think that he starts with a flawed premise about probable cause, being like he's making it out as if it's a joke to get to probable cause. And I don't think it's quite the joke that he's making out to be. Joe, you're amazing. Oh, thank you. You're too kind. You gave us perm, excellent logic. Your dad, I love your love of your Jewish faith. Oh, thank you so much, Pam. You're really kind. I'm very concerned with the glee with which people who are formerly admired or work with someone decide to attack him when he fails at life. The correct emotion would be sorrow. Yeah, I agree with you on that. I agree with you. If in fact you're doing in good faith, but glee gets a lot more shekel.
Trying to meet isn't high. The quality and standard kind of run parallel. Obviously, we could use higher quality evidence. That's fine, but we're only trying to reach a 1 out of 10 standard, so 1 out of 10 evidence will typically be fine.
See, and this I disagree with him also. I think what ends up happening here is in the totality of circumstances at the probable cause stage, we will allow you to pack in there stuff that could potentially turn out to be crap. Less reliable evidence. But that does not mean that the yardstick now falls below preponderance level. And I actually think it is closer to preponderance level than he's making it out. I actually think if you want to think about logically, it should be a tiny bit over 50% more likely that the person's committing a crime than not. If we're going to authorize the police to and give them license to break into someone's house and start tearing through their stuff, we should say, pile together all the sources you have, reliable, unreliable, let the judge know how reliable or unreliable they are, and let the judge come to conclusion, I think it's more likely than not that they committed a crime. Or about to commit a crime. But not that it's like, let's we're going to take all sorts of crap, and then you don't have to reach a very high. Then, if I think you might be doing a crime, you might want to be, you might be interested in doing a crime. Well, in that case, it's very low level. You only have to get to that. I don't think that's true. I disagree with him on that.
So, that's fine. So we turn our attention to this hearing in which Nick is going to raise these issues and discuss it. I have not read this before, but we'll read it together and see what it has to say and see what the arguments looks like and try to reassess the probabilities. So far, I'm not very optimistic on Nick's possibilities here. I think that Nick's very unlikely to get this to win, but we'll see if the argument changes it or makes.
I think about an idea that this Kurt, you're here in the chat. Okay, welcome, my brother. And I told Kurt before I did this stream that I was going to be doing it. I didn't want it to be like he's a friend, and consider him a friend for years now, a good friend, and I didn't want him to think I was like blindsiding him, which is why I just gave him that. I figured it's appropriate to give him that heads up. You think saying it's 5 doesn't make sense. If 5 was required, that'd be enough evidence to win a civil lawsuit, and that seems wrong. Why is that not it wouldn't be enough to win a civil lawsuit because you're able to pack to get to that 5 with hearsay and other evidence that's not very reliable. But before we say, hey, look, the police are going to go into someone's home and the court is going to say, go ahead, tear through their entire lives, rip out everything there, I would think you have to be like, okay, gun to my head, based on what I heard, if everything I heard here was true, would I think that they committed a crime? Yeah, more likely than not, they committed a crime. But you at least have to get to more likely than not they committed a crime. Not, I'm going to take all this crap evidence, and with this, I still, gun to my head, I don't think they committed a crime, but it's okay for them to, but let's go search anyway. Maybe we'll find something. I don't think, I respectfully, it's a lower yardstick because the quality of evidence that's admissible to get to that preponderance is a lower quality than would be admissible in civil courts. But it still, to me, should be that more likely than not that a crime has been committed or is about to be committed.
The calculus change as we go. So we'll see. Anyways, we've got Kristen Pierce, who is here for the county. We got Francis White, who is here on behalf of defendant. And of course, Nicholas here, who is also here. So this is Nick's omnibus hearing. Not to be confused, presumably, with his wife's omnibus hearing, which might happen at some later time.
Yeah, it probably only happen.
The court will call.
It probably only happen if Nick wins. Then you would bring it for Kayla also. If Nick loses, you figure, why are we going through this twice, right?
Court file 34 CR 24-341, State of Minnesota versus Nicholas Rekieta, who does appear with the attorney Francis White. Kristen Pierce and Jordan Engler appear on behalf of the state. The matter set for omnibus hearing here today. Mr. White, do you have some contested issues? Yes, Your Honor, we do have contested issues. Okay, I would ask that you remain seated since we can pick you up on the mic much better. No problem, Your Honor. Yes, Your Honor, and if it may please the court. Solid. On Sunday, we filed a motion asking for this court to strike all evidence, to suppress all evidence that was collected under the warrant. We based our motion on the two-prong test in Franks, a case in which I'm sure the court is very familiar. Yeah, Franks is one of those backbone cases when it comes to searches, so kind of comes up a little bit.
With you, solid. It's definitely, it doesn't harm Nick at all for Kurt to be making this assessment here. It doesn't. And he clearly is not doing it with the same type of glee that's referenced here with other people when they went after Nick. There's no glee at all. It's a matter of like, look, I just don't think your motion's good. I don't think this is a winner. So, and it does help you to hone your arguments if you have someone who's, independent and trying to, and an intelligent experience in the law who's sitting here trying to break down for you as to how good or bad the argument is, rather than just, saying, yay, you got this, you won. That's, you don't get better that way, right? You only get better if you're being tested. Pam, remember, for 9 months. That's right. 3/4 of a year. That baby's popping.
As you might expect, it's pretty frequent. Yeah. Under Franks, there's a requirement that the statement is made by the reporting officer was false or reckless disregard of the truth, and the statement was material. Correct. That is essentially the standard. You can't lie. You have to disclose. You have to disclose any fact that would be going the other way that you know about. So you can't make up stuff. Everything you say is true. Everything you say has to be true. You do have to disclose any evidence that you happen to know about that goes the other way. And if you do lie or misrepresent, the lie has to be material in some way. Cool. In order for it to impact the warrant. Cool. As indicated in the motion that we filed.
I agree with that. I agree with his assessment there about Franks. Again, I'm not a criminal defense attorney, but everything I've seen about Franks, that seems consistent with the law. But I'm not going to agree with his full assessment in this first argument that we're going to get to here about the kids and stuff related to the kids. And I'll walk you through that.
Well, I believe that both of the legs upon which Deputy Pomplin, I believe is his name, based the motion or based his request, I believe they're both faulty. As I pointed out in the first instance for the warrant, he based that on hearsay, which I concede is admissible, as I said, right? Because hearsay is admissible in a probable cause. Yep. But hearsay from a reporting official a mandatory reporter who reported something to another officer, that officer, Sergeant Nestor, forward that information to Candidato County and Human Services CPS, and CPS rejected that, which is true insofar as it goes as it relates to the child abuse issue, but that isn't why we got the warrant. See, if we got the warrant because we're looking for evidence of child abuse or child neglect, then if CPS said, hey, we don't think there's evidence of child neglect here, or our investigation says there's not, then yes, the officer would be required to put that in the warrant, which doesn't necessarily mean that the warrant won't necessarily issue anyway, because maybe there's evidence beyond what CPS considered, or maybe CPS has their head up their ass, right? So just because CPS says a thing, either way, incidentally, doesn't make it true. CPS could have their head up their ass either way. They're like, yes, there's totally child abuse here, but there's not. Or there's not child abuse here, but there is. But either way, if CPS tells you, hey, we don't think there is a problem, that's the kind of thing you need to disclose in the warrant application. But you only need to disclose it in the warrant application if you were searching for evidence relating to child abuse, because then you have evidence that goes the other way that you know about. You have a conclusion from a competent government official who says, no, we don't see it. So then you're like, yes, I disclosed that. And by the way, here's all the reasons that CPS is wrong. And here's all the other evidence that goes the other way. So what do you think, Your Honor? Do you think there's enough evidence or not? Right? That's what judges are for. That's what judges are for. Judges make the final call. CPS has an opinion. The police has an opinion. Other people have an opinion. The judge makes the final call. That's what they're for. But you have to disclose that. But you only had to disclose that if you're searching for evidence of child abuse, child neglect, but you weren't. The evidence that the warrant by its own terms is searching for evidence of drugs. So the only evidence that you'd have to disclose would be evidence relevant to that search. So CPS's opinion relating to child neglect is kind of neither here nor there on that issue. So I don't know why it needs to be mentioned. That's what I...
Okay, so let me break down what he's saying here, and where I kind of agree with him, but for completely different reasons than what he says. Okay, so what he's saying, and there's wisdom to what Nick said, what Kurt's saying here, in the sense that he's like, okay, look, if this was a warrant that is seeking to get you admission into the house to find evidence of a crime of child neglect, and you leave out something that, hey, the state says this isn't enough for child neglect, well, in that case, then it becomes relevant. But since this was about drugs, so the child neglect assessment from the state loses its sense of relevance. This is where I disagree with you, Kurt. Okay? Why is it in the warrant? Why are they talking about this at all in the warrant? Meaning, what's the point to putting this in here? If the point is to putting this in here is to tell you that, hey, there are kids in danger. We think there are kids that may be in danger here because of his drug use. To me, it seems as if the objective here by Officer Pomplin in talking about all these people who have duty to report, who are coming in here and saying, we think there's calamity going on in the Rekieta home, and yet CPS is saying, that's not enough. Well, you would think that, like, okay, once you're trying to use that to bolster your argument that there's a reason for us to go in here, well, in that case, the judge should know that needs to be taken with a significant grain of salt based on the assessment of CPS. So my first starting point was like, I disagree with your take on this, because I think that the only reason it's being mentioned in the warrant application at all is because you're trying to say, why are you talking about the kids at all? It's for drugs. Why are you talking about the kids at all? Why are you talking about, like, people saying the kids smell or whatever, kids are hungry, whatever. Why are you doing that? And I know you're going to address this later on. I went through your video. I know you're going to address this later on. You're saying that the reason that is brought in is not to say, and this is what he's going to talk about later, and maybe we'll skip through that or not, like when we get to this part later. Probably won't end up skipping through it. But what you're going to end up saying, what you're going to say is, it's not that we're talking about the children for the purpose of saying that there's a crime being committed with respect to the children. It's that we're talking about the children because the potential neglect of the children should come into the entire calculus as to, are these people on drugs all the time? And since they're on drugs all the time, they're too drugged up to be able to take care of their own kids. Essentially, that's what essentially the argument is. And if they're too drugged up, take it. So that's part of the calculus that I think Kurt is trying to make here, where he's like, for that element of are they doing something illegal with drugs? That's why the kids are coming in here. And so who cares about what CPS says? What I would, with respect to this particular argument that Kurt is making, my first gut is I disagree. But then by the time I finish this analysis, you're going to see I kind of end up to a degree agreeing. Say that 3 times fast. Okay. When they're bringing it in here, I understand that from a looking at a basket of information, you're trying to flesh out your totality of circumstance. Say, oh, you want to know how I know they're on drugs because because the kids are neglected, and that's a reflection of the fact that you don't have your crap together because you're too drugged up. Okay, essentially that's what the argument is being made here. That I'm only talking about the kids, not for the purposes of saying there's a crime with the kids, but in order to tell you that they're too neglected. Well, let's say if CPS's letter is basically coming out and saying, no, that's not, we visited there and there's no signs of neglect there, then I definitely think you have to put that letter in there. I mean, you have to put that letter in there. The reason I'm going to conclude in actually sort of agreeing with Kurt on this element is this. From what I recall of the letter, and I don't have a copy of the letter here with me, but I did look at this letter back in late May, early June, I believe. But I looked at it months ago. I believe that letter says we don't think there's enough here to get a search warrant. And if that is indeed an accurate assessment, what the letter says, that there's not enough here to get a search warrant, that's not really defending the Rekietas here. It's not really defending them. It's basically saying this alone is not enough for a search warrant on this crime. So is that saying that the assessments that were made by some pastor about the kids, or some teacher about the kids, or some neighbor or whomever about the kids is inaccurate or is refuted by CPS? No. It doesn't mean that. It simply means that these reports are not enough to justify a warrant. So really what comes down here as to whether or not this is a critical omission by the police officer is very much related to the wording of the specific letter from CPS. If that letter comes out and says, hey, we heard reports about these kids smelling, we went there and we saw no signs of the neglect that they're talking about here, then 100% that has to come in this police report. That has to come in. If they say, hey, look, we went there, we saw there's plenty of food in the pantry, everything here looks like, the clothes are washed and everything like that, that has to come in there because it's mitigating against the claim that you're trying to introduce here that people say that the clothes are dirty or they're hungry or whatever it is. It's like, no, they're not dirty. They're not hungry. CPS was in there and said they're not. So that must come in there, even if it's not a crime about the kids, because you're trying to say, hey, I know that they're a drug addict because these kids are not being properly taken care of. Well, you know what? They are being properly taken care of in the estimation of CPS. So if CPS says they are being properly taken care of, and I'm not saying that's what they said, I'm saying if the letter from CPS says they are being taken care of, in that case, that letter must come in, and that's a glaring omission from the police. However, I do not think that that's what the letter says. As I understand it, the letter says, we don't think there's enough here. We don't think there's enough here is not really refuting what the pastor's saying. It's not refuting what the teacher's saying or any other persons who came and reported were saying. It's not refuting it at all. It's simply saying this ball of wax related to the kids is not enough for a warrant. And if that's all it's saying, in that case, I end up concluding with Kurt that that's not a glaring omission. Because it just means, hey, standing alone, that's not enough. And in fact, if there was nothing else in this affidavit, in that case, okay. But the CPS doesn't know about about video. CPS doesn't know about other stuff that they have here, other reports that they have here related to the drugs. And accordingly, or other evidence that's being submitted by Pomplin, where he says, I saw him 6 months ago, I saw him here, I saw him there, and the track marks, or all the other stuff that, you know, people are making claims about Nick Rekieta. And I'm not saying any of those claims are accurate or inaccurate. I'm just saying this is the ball of wax that's being handed. This is the whole pie that's being handed to the judge who's making this assessment. So in that sense, I have to come out assuming it all comes down to the language of the letter. If the letter says refutes some of those claims, the legitimacy of some of those claims, it must come in because it basically would serve to tell the judge they're not actually being neglected. If in fact the letter does not say that, it simply says, look, we don't know if those claims are true or not, but even if they're all true, that's not enough for a warrant. In that case, I agree with you, Kurt. It does not need to come in. Because that ends up being basically a legal conclusion. It's not even a factual conclusion. That's their legal conclusion is this set of facts that may or may not be true is not, in our estimation, legally sufficient to justify a warrant. And I agree with you that if the letter is only a mere legal conclusion, in that case, there's no need by the officer to put it in there. That makes sense? I think that I don't think that's I think Kurt would probably agree with me on that assessment.
I think the latter estimate, and also, of course, by the way, as I sort of said in an earlier searches, investigations mature. So it could be, of course, the case that the pastor initially came on child abuse, child neglect charges or concern.
Yanni asked me a question here in the rant saying, if you don't trust what the cop's saying, why don't you want to see the cop body cam footage? I never weighed in on whether or not I want to see the cop body cam footage. I don't remember weighing in on that issue. I'm fairly positive I've never weighed in on that issue at all. So, yeah, I'm fairly positive I never did. The only thing I did weigh in was an hour or so ago where I was saying if there are kids on there, you know, in that case, you know, the creepy people with respect to kids. But yeah, I don't remember expressing an opinion on that.
It's because that would make sense. The pastor in this state is a mandatory reporter. Clergy are mandatory reporters in something like 20 states. So the list, you know, not every state, but something like 20 states they are. Minnesota happens to be one of them.
Well, hell, good logic. My friend here, George, a giant slayer. You're always killing my friend. Just love your point. Insight and common sense that cuts through these crazy times. Thank you. I appreciate that. And Uncivil here is basically saying, I'm making a fair point here. The probable cause is a higher yardstick than what people are accepting it to be. So there you go. At the end of the day, I think Kurt and I are both trying to figure out truth here on this.
So if in Minnesota, if a pastor, priest, clergy of some description is aware of abuse against a child, let's keep it simple, then they are required to report that. Incidentally, of course, as you might be interested, the law on this has changed. That didn't used to be true, where pastors, priests, and clergies had to disclose. But that largely changed, although not entirely, but largely changed as a result of the Catholic abuse scandal. A lot of states, as a result of the Catholic abuse scandal, were like, you know what would be a really good idea? Maybe if priests were required to report the abuse to children instead of necessarily keeping it in-house. So if you're curious on the impetus for the legal change, that went a long way. But sure, either way, right? They have a duty to disclose. But that might have been the initial impetus, but that isn't necessarily where things stopped. The police might have gone investigating child abuse, child neglect, and along the way found evidence of a different crime, which if they did, then that's fine. And then they can choose which crimes to investigate or not, depending on their own priorities, because they're the prosecutors, or part of the prosecution at least. So they choose to kind of follow the investigation wherever it goes. So they're investigating one crime and then they discover evidence of a different crime and then they investigate that for a while. Cool. We didn't find a lot of evidence on the child neglect. Cool. But along the way, we found some evidence of the drugs. So just because the initiation of the investigation may have related child abuse, child neglect, doesn't necessarily mean that's where the investigation stopped. Just because the priest went initially with, I'm concerned the children are being...
What's interesting is this. So if you, I mentioned at the outset here how I joined Nate the lawyer and Kurt on Nate's stream right before I came on here, like 20 minutes beforehand. It was just a quick, like 5-10 minute appearance I made there. And what he's talking about in this context is prior to the search warrant. So the investigation starts in crime A, and as we're digging deeper, we find more proof about crime B. And that's, you know, that's the way things tend to, will frequently unfold with respect to a police investigation. That's natural and normal. What's interesting that with respect to what he's talking about now is I went up there to debate Kurt and Nate based on a position that I believe is what Robert Barnes and Nick were taking, which was arguing about a situation where once the police have a warrant for crime A, now they're in the house. Everyone's under arrest. They're doing their search. And people are sitting on couches in cuffs, and they have control of the situation. And now they find evidence of another crime. They want to seize that evidence and take that evidence for themselves to prove a different crime that's not listed on the search warrant of things that they're allowed to take. Now, what I heard Nick talking about on his stream when he was breaking down this omnibus motion that he had filed was that, and he was disagreeing with Kurt's assessment on it, was he was saying that, okay, start with this understanding. Start with an understanding that it is always illegal for the police to come into your house. That's the Fourth Amendment. It's unlawful. You cannot be subject to unlawful search and seizure. Someone coming into your house is unlawful unless it's made lawful by going through certain steps in process, certain steps along the way. And those steps have really been fleshed out by the Supreme Court as to what those steps are. So if you now, it becomes lawful with respect to, hey, we have probable cause that you're committing crime A, now we're in your house. So what Nick was saying is one element to a warrant, there's actually two elements in the same warrant. There's the element of that you have a warrant to search, and then you have a second element to the warrant that you have a right to seize. Both of them tend to be incorporated into the same warrant. What do you have a right to seize? You have a right to seize evidence of crime A. So what I understood Nick to be arguing was that if you come in there and you have a right to seize evidence of crime A, and while you're doing your search, you find evidence of crime B that's not anywhere listed on the warrant, that he was making the claim that it is illegal for them to seize that without getting a subsequent warrant. And while there are exceptions to that, if it's a dangerous situation, if things are going very fluid, if you don't have control of the whole environment, then those scenarios you don't need to go through the whole search and seizure warrant element with respect to crime B. That when you do have a secure house, when the police are in control of the whole situation, and there is time to sort of settle down, cool off, and allow a judge to decide that you have the right to seize evidence of crime B, that is a necessary procedural step. And failure to comply with that necessary procedural step would result in a wrongful seizure by the police. And that evidence would have to be suppressed. That is the argument I understood Nick to be making. And I could be wrong in what he was saying. That is the argument I understood him to be making. And it made sense to me when I heard him say it. And again, I am not a criminal defense attorney. So I was like, okay, that's interesting. I can understand that. And that makes sense as a claim. When I brought this up, Uncivil found a case from 1990 called, I think, Horton versus California, a Supreme Court decision, which expressly says, if you go in there with a lawful search for crime A, and they specifically say not for crime B, and then you end up taking stuff for crime B, that's in plain view. It's staring you in the face. You're not doing extra searching, but it's sitting there staring you in plain view that, hey, here's crime B, that you're allowed to seize that now, because you got entry there lawfully and it's sitting there staring you in the face, that under Horton v. California, the Supreme Court says you can seize it without getting a subsequent warrant. Well, this is a legal question, which I think Uncivil, I immediately said to him, okay, there's the answer on the law. You're right. Which means that if in fact this warrant is lawful, which is what they're arguing about in the first place, is there enough here for probable cause, or was there, there was too many omissions in the affidavit in support to warrant probable cause or to invalidate the warrant? So in that sense, but with respect to the guns that they seized, which are not listed anywhere in the warrant, based on Horton v. California, which was decided by the Supreme Court, I think you probably can say that, hey, they're probably going to be able to, the state will probably be able to keep those guns as evidence and they will not be suppressed. That's my legal assessment based on this case, which Kurt brought up there, did a little quick digging and found that out and pulled it up there on stream. So I think that they probably will keep assuming that this warrant is lawful, I think they will keep the guns. The state will keep the guns, I'm saying, as potential evidence of a crime. The cops are doing extra searching, and that's why the prosecutor agreed with Nick. Okay. Well, if they were doing extra searching, that it was extra territorial regarding. I don't know how you would have that. I don't know where the cops agreed to that. You sent me a chat earlier that I don't know if I pulled up. I think I know you sent me something, Kimmy. Maybe I missed it. I don't see it. Yeah, that's what you said earlier, but the prosecutor agreed with Nick. I apologize if I had to pull this up earlier, Kimmy. I'm sorry. And remember, for 10 minutes, I'm going to give you a horn just for that. I didn't see where the prosecutor agreed with Nick. Now, maybe in this omnibus hearing, from what I heard, they were like, I think we need to put in legal opposition. Saying we need to put in legal opposition is not agreeing with Nick. So I'm not sure where you saw that the prosecutor agreed with Nick. And it's possible I missed something that broke on this story. It's possible. It's not like it's not like I'm living and breathing this story. It's like, it's interesting to me. I hope he succeeds, sorting his life out. But it's not like I'm sitting here, scouring the internet for updates on the Nick Rekieta case. But I'm not familiar with the prosecutor agreeing.
Neglected doesn't mean that's where that stopped, and apparently wasn't where it stopped, because eventually they got a search warrant for the drugs, which is different. So that's notable. Okay, the letter that I submitted as an exhibit clearly shows that the first artifice was rejected by Candido High. As it relates to child abuse, child neglect, that appears to be true. Although strictly speaking, of course, ultimately that would be a decision for the judge. CPS's opinion is interesting and all, but not necessarily dispositive. Because you can be like, no, I think they're wrong. And if you have enough evidence, then fine. Either way, incidentally, they can be wrong either way. That's why we have courts to adjudicate things. But even if it had been rejected, the plain language is what is alleged in his request. His application doesn't rise to the level of anything to do with drugs. Child endangerment, perhaps. I'm not sure I see it that way because the warrant seemed to be based on the drugs, but okay. The language in there reflects nothing but child endangerment best, and I'll even concede it doesn't do that. Well, no, I don't think I necessarily agree with that. I mean, the issues relating to the children not being washed properly or clothed properly or not being fed properly is potentially evidence of child neglect, obviously, but it could be evidence of something else, right? So the children.
This is what I talked about before, as far as using that scenario there to try and prove not the obvious crime of neglect of children, but the less obvious evidence that this tells you that they're probably high on something.
Because the warrant talked about the children, not their clothes not being washed or their clothes being dirty or them being hungry all the time. It's like that might be an issue of child neglect, but it might also just be issues that there is something else going on. For example, the parents are being distracted by their drug use. So I don't necessarily concede the point. I mean, child abuse, child neglect, child endangerment can obviously be a charge unto itself, but it also can be evidence of a different charge. So it can be the end, but it could also be the evidence towards an end. So I don't necessarily agree with that characterization, but okay.
The state agreed with his argument about April's Fifth Amendment rights and agreed to not use her statements unless she testifies. Yeah, but we're going to see here that's not really the argument that they're presenting. It's not a confrontation thing, it's a hearsay thing, which I think Uncivil covers very well in this video, actually. It's not just plain view, but also in locations that could contain evidence you're seeking cannot search for stolen cars and desk drawers. Yeah, this is the whole elephant in a suitcase thing. We're looking for a stolen elephant. You can't look in a suitcase. Right. But when you're talking about searching for drugs, I mean, seriously, what could you not search to try and see if drugs are hidden there? I mean, can you come up, you can go through every tiny little box as being a place that there could be drugs in there. So what are you not going to be searching in?
The second element is that Deputy Pomplin said he watched a video on Steel Toe morning show by a gentleman by the name of Aaron M. Holt. Aaron M. Holt and the defendant have I don't want to say a long-standing feud, but it's gone on for months. They don't like each other. It does appear based on my understanding that things are not necessarily going great as it relates to their relationship between each other. That does seem to be true.
You think? Yeah, that's Uncivil's patented specialty and understatement right there.
They plain old just don't like each other. And from writing in the particular application, it seems as if the deputy identified Mr. M. Holt and his exploitation. There's almost a concerned citizen. Okay. But okay, this is also interesting too, because to the extent that the cop would be required to disclose that M. Holt is biased, to the extent that they'd be required to disclose that, they'd only be required to disclose it if they knew that. So if they don't know that, they don't have to disclose it. The case law is fairly clear, right? In a search warrant, they only have to disclose things they actually know about.
Yeah, but he says he watched the video. I don't think you could watch any of those videos that were happening May 21st, 22nd, anytime in that time frame, and watch him for 10 minutes talking about Nick and not come to a conclusion that this guy hates Nick. I mean, it's pretty obvious. He does not like Nick.
So whether or not there is actually animus or not, the cops only have to disclose if they were aware of the animus at the time. And even then, the question would be like, do they have to disclose it? But they would only have to disclose it if they knew about it. And
to be fair, in the statement, they actually addressed the fact that there was a falling out. And this is an interesting thing, is if the cop undersells in the affidavit just how hostile the relationship has become, and basically makes it like, okay, they're not friends anymore, versus like, no, they're bitter enemies now. They practically need to get restraining orders against each other. So, is that? It's not like, oh, we're just, we're not keeping up anymore as friends. It's like, no, there's genuine animus there. So, and the cop sort of frames it as, well, they're not hanging out as frequently. By saying, well, there was a bit of a falling out. I don't know. Would you expect that the court who's reviewing this and trying to decide whether or not to give a warrant would sort of glean from that, okay, maybe this guy hates him? Because you might say, hey, you know what? When the judge reads a cop who's trying to get a warrant saying there was a falling out, I think the court probably knows that falling out means animus. I don't think that's an unreasonable take to have. Because we're sort of trying to sit here and say, what information was available to the judge at the time she issued this warrant when she's looking at this and she reaches this conclusion? And the warrant is going to stand unless there was a real abuse of discretion. It's got to be real abuse of discretion. It's got to be a terrible mistake by the judge here. So now, if the state had lied to her and said they're best friends, this is what his best friend is saying, that would be one thing. Now the judge is, like, oh my gosh, his best friend is saying this about him. But they said someone who had a falling out came and told us this. Maybe they don't have to go into detail as to the level of animus, and we say a judge should be able to read between the lines on that one. I think it's a fair assessment to make. Oh, that's very kind of you. She'll be lucky enough to have a friend like you. Thank you very, very much. It's very, very thoughtful. I really appreciate the generous super chat. Thank you, Tracy.
They didn't know about it, then they wouldn't have to. So if they didn't know about it, then they don't have to disclose it. Well, the case law is very adamant that he doesn't qualify as a concerned citizen. Because when you're dealing with the concerned citizen analysis, you look at what the motivation is. The motivation is important to determine whether someone's a concerned citizen or not.
I looked, and that's actually true. I researched Minnesota case law on this, and they do say that if it's not a concerned citizen, in that case, you need to have some sort of level of, my recollection is it said some sort of corroborating evidence that just his statements, we don't trust it if it's coming from someone who's a rival, which is logical. It's a logical approach that Minnesota would be taking there. So Nick's lawyer is trying to say, hey, look, he's trying to portray him as a concerned citizen so that he doesn't have to come up with this corroborating evidence. And that's crap because it was actually a bitter rival of his. So that was misleading the judge. The judge ended up getting bad information from the state because the state intentionally misled the court. And that's the only reason that they came to their conclusion. I do think that the state may have saved themselves just by that little reference to a falling out. I think it's possible they did.
I'm not sure that's necessarily completely true, but okay. Also, the video, and stated in the evidence, the video he watched couldn't have been the defendant's. Well, it could have been, just not necessarily from the defendant's site proper. In fact, the evidence that we've received in Discovery in their supplement shows a clip from presumptively the video that he watched, showing it came from a different platform, and a different platform added elements to the video, such as the watermark. I mean, come on. In my opinion, come on. So the video in and of itself is not reliable. Well, for trial, probably true. For trial, we're going to want the original. It's the best evidence rule, or it's variance under state law. We want the best. We want the original. We don't want to hear about it from a guy. We want to hear about it from you. We don't want to see a copy of the thing. We want to see the original.
So this is where I think you're making a mistake here, Kurt. Okay? If you're hiding how much this guy hates Nick, right? If you're hiding how much this guy hates Nick, and you're hiding the fact that it's a doctored, it's not the actual original. Let's assume that it really was not the actual original that the cop was able to see, which is what Nick is claiming was impossible to see because it was made private. So unless he was watching live while it happened, which is not what his claim is, in that case, it would be now a doctored, somewhat doctored. And once we know it's not the original form, once we know it's been some way manipulated and it's being presented by a guy who's an enemy of Nick, well, a judge might say, okay, so now you have here someone who loathes Nick playing with a video and now presenting a video which makes it look as if he's on drugs. So now we should believe it's more likely than not that he is on drugs. Now, I want to be 100% crystal clear on this, okay? I am not saying that Aaron doctored the video in any way, shape, or form to try and make it look as if Nick was on drugs. I don't think he did. I think that would be a false statement. I'm not trying to say that. What I'm trying to say is this. We are looking at the totality of circumstances presented to this judge and whether or not she had a fair way of reaching a conclusion that there is probable cause here to justify breaking from the norm that you're not allowed to go into Nick's house and saying, no, now we can go into his house because there's probable cause that he committed a crime. So when we're trying to look at this calculus, we have to sit here and say what information was available to the police officer, what information was presented to that police officer, then present to this court. And if they had presented, and if it's skewed information, and they had presented accurate information, that there's, we have reason to believe that the judge would have reached a different conclusion. Now, all of a sudden, those changes become material. I don't think it's fair when we're assessing this to say, okay, probable cause, you don't need one thing. You look at the totality of circumstances. Okay. And that's the way the law works. So if we're looking at the totality of circumstances as a basis to try and get to this hurdle of probable cause, should we not also look at the totality of circumstances as to what the cop has said to try and say the totality of what this cop did pushed this judge beyond where the judge likely would have gone. Now, what I'm saying is this. CPS looks at all these different factors with respect to the kids. And this is a little bit complicated what I'm explaining here. So I'm going to make myself a little bit larger here so I can confuse you all the more. Okay. Think about this for a second. CPS, look, here's all his complaints about the kids. Kids smell, there's not enough food, they're hungry, he looks like he's driving around tired, he's got track marks, all these different tiny little things that any one of them, if you took them out and plucked them and threw them in the garbage, not true, false, threw in the garbage. You still have a totality of circumstances here. And you'd say, oh, okay, we have enough here to give a search warrant. Because we're looking at the big picture. We're not looking at this thing. We're looking at big picture. So we're looking at big picture here in order to say, now we have gone from you cannot legally go in there to say, nope, there's probable cause. We're going to issue a warrant. Now you can legally go in there. So we're going to jump over that probable cause threshold and now make it legal for you to go in there. How? Because we looked at the totality of circumstances. We say the totality of circumstances is what got us across this threshold. It's not this any one thing. It's not any two things. It's the whole 20 things. This little piece, that little piece, this little piece, that little piece, this little piece, boom, 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 boom. Now we think it's more likely than not that a crime is being committed. Okay, great, fine. All that consistent with law, all that accurate. Now we say, hold on a second. Some of the things the cop presented here, not so kosher. It's not so clean. For example, he left out this CPS thing. For example, you left out this thing with Aaron Imholt, not just having a falling out, but like practically threatening Nick, keep your effing name out of my mouth, and all sorts of really hostile things about Nick, where it's like he seems like he's really an enemy. And now we also leaving out the fact that what the cop looked at was not Nick's live stream or something he found on Nick's channel. No, he's looking at something that was in some way or another affected by this guy who hates Nick Rekieta. So now you're a judge. You haven't seen this video. You didn't see the whole thing on May 22nd where Nick is sitting there looking coked out of his mind, like Tony Montoya there, and going with the whole thing, looking like he's doing an imitation of Donald Trump, talking about that reporter, right? You didn't see any of that. All you're looking at is this affidavit from a cop. And you're saying, okay, do I think this is enough here to reach probable cause? Well, you know what? If you're sitting there and there was another, and Nick's attorney was sitting there and was saying to you, and you were able to see that side of the fact, the things that the cop left as an omission, and look at those omissions, the totality of those omissions, you might then the judge might very well say, I don't think we reached the threshold here. That's the point I'm getting at. So, because if a judge is looking at this and hasn't seen the video, didn't see him having his little shakeout fest. So I can understand Nick's counsel being like, okay, so how would a judge know whether or not this guy who's an enemy of Nick literally doctored the video itself? The judge thinks he saw the original because the cop implies, I saw the original. To the extent, let's assume that the cop applies this in his affidavit, which I'm not saying he did, but assuming the cop actually leads the judge to believe he saw the original and hasn't. Instead, he saw something that was presented by a bitter enemy of Nick. So you're telling me it's impossible that your bitter enemy would not have doctored a video in order to make it look worse? How hard is it? How hard is it? You could literally splice in there Tony Montoya and him put him in a restaurant, whatever, for all you know. And imagine, and Aaron did not do this. I want to be clear on this. He did not do this. But imagine Aaron had basically, instead of taking that video and showing that video on his stream, imagine he took the same background of Nick there, spliced Nick out, and then showed Tony Montoya there. Literally Tony Montoya from Scarface. okay, in the restaurant there, where he's falling into a thing of coke, and he thought it was funny, right? So let's say he actually did that, which probably, if you're a video guy out there, it's probably pretty funny. So when you had literally Tony Montoya there falling face first into like a mound of powder, and now imagine that the cop took that and said, "Oh, look, I saw this video here. Nick looks really bad. It looks like, I see some powder on his nose," and presented that as being truthful. Everyone here watching this would be like, "Are you out of your freaking mind? Are you crazy? Are you a lunatic? How the hell do you put that in as evidence?" Now, I know he did not do that, Aaron. My point is, if Aaron had done that, Officer Pomplin literally could have written the same words that he wrote. He literally could have written the same words that he wrote. So there's no way the judge doesn't know that that's what happened, because he doesn't mention that, "Hey, I saw this on the channel of a guy who hates him. Hey, I saw a video that was not the original. I saw something that was presented by this enemy that I saw on his channel over there." Because if I'm sitting there as a judge, I'd be like, "I don't even know if it's like I don't know, it's really Nick Rekieta that you saw. I don't know what the hell you saw there." Now, do I think he actually saw the real Nick Rekieta? Yes. Do I think that everything that the cop presented was accurate? Was probably materially accurate reflection of what actually appeared on Nick's stream? I think the chances are astonishingly high that they were. Okay, I don't want anyone to take me out of context on this. I'm looking at this as a constitutionalist perspective and saying, if you're Nick's lawyer here, you want to be making this claim that, hey, the totality of circumstances to how the cop manipulated this affidavit. If he hadn't manipulated and he actually gave an accurate assessment, CPS says that this is okay. My concerned citizen is actually someone who wants to see Nick drop dead. The video that I saw is not the original video. And he put all that into the affidavit. A pretty good chance the judge we don't have probable cause here. So, does this mean that Nick wins? No, it doesn't mean he wins on this motion. Absolutely not. Doesn't mean I think he should win. I don't even get to that. I'm not even sure I come to that to that level where it's like I think he should win. I'm sitting here and saying this is how his attorney would present it, or present it to the judge here, as far as why it is that this merits a Frank's hearing and should be overturned. So that's what I'm trying to do. I'm not saying that this is. I'm simply trying to give you the perspective. This is best case scenario perspective is how defendant would look at it. And I know that this is just inviting people to start screaming, sweep, 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 like losers, because they don't understand that I'm trying to actually give you legal perspective here. And I'm saying this is how an argument would be made. And you can understand that argument being sound. Does that mean that this is enough to knock out the warrant? No, I'm not saying that at all. I don't know. I'm simply saying that I feel as if when Kurt is going through this, he's doing what any one of us would typically do, which is like you just sort of look at each argument and be like, that's not a big deal because it's just CPS and they have their opinions. That's not a big deal because they say falling out. And you can keep picking off one thing after another. And you say, since I'm picking off this thing, and then I pick off this thing, and then I pick off that thing, all of a sudden now, this probable cause looks impenetrable. But when we're building probable cause, we said, oh, okay, let's pick off we didn't let you pick off all the things and then pretend they didn't happen. We said, okay, we'll take it's a little bit less powerful, but it's still there, a little less powerful. It's still there. But it seems as if when people are ripping apart this motion, they're like, now that I've knocked this thing off, let's pretend it's not there. As opposed to looking at the totality of circumstances to knock off the probable cause. That's what I'm getting at. I hope that was clear. And again, I think I know that Kurt's doing this in good faith. I'm simply saying, okay, you want to knock this thing off CPS? I can help make an argument for you on that. You want to knock off the thing about the concerned citizen? Yeah, I agree with you. They did say falling out. The cop did say falling out. Yeah, it's a very generous assessment towards the neutrality of Aaron Imholt to just refer to as a falling out rather than just like they want to see each other dead. But you know, there's reference to the fact that they're not friends anymore, and there might be some animus there that the judge could have picked up on. And you want to tell me that the watermark, that's not anything? It's not the watermark. It's the fact that the judge doesn't know that this is not the original. If the judge thinks it's the original and doesn't know it's been manipulated, well, then who knows how much has been manipulated? And even though I know how much has been manipulated and that it's not that much has been manipulated, the judge sitting there trying to decide on the warrant doesn't know it at the time that she's making the decision. That's the point. Did you see the Barnes segment on this? I didn't review the Barnes segment. I know that they were going over this, but think about the problem you have with the nursing home. I think lots of problems with the nursing home. You're talking about the nursing home that was closing down. I'm not sure what to do with that. Who said that video came from Aaron Imholt? Nobody else has said that. I thought he watched it on Steel Toe Morning Show. That's where I thought he watched it. If I was mistaken about that, then that's a significant, that's a material factual element. I understood that that's what he said in that affidavit, but I looked at that affidavit a long time ago. Outside Nick, this is scary to a father like me. My dad has type 2 diabetes with kidney disease. It's scary that some cop could have gotten warrant for this level of search with the same fact pattern. We should all be looking to make sure that the police are doing their jobs properly. If only to make sure, if only for your own self-preservation. Hey, potential criminal. Nick's attorney admitted that Nick and Aaron just don't like each other. That defeats the claim Aaron is evil and hates Nick. Does it? Does it? How does that defeat? I don't understand how that defeats the claim. How does that defeat the claim? Let's say they really despise each other. The point is he's not a concerned citizen. How the hell does that defeat the claim that Aaron is evil? Maybe both Aaron and Nick are evil. So anything either of them says by the other, we have to assume is complete BS. Got it? I don't know. I don't understand how that. I don't know how that also now makes the fact that Nick hates Aaron. How does that now give Aaron more credibility? I don't understand that argument. The cop admitted to the judge that he did not see the original video. So I gotta pull up his affidavit. I got very confused by what the cop wrote on that. Let me see if I can pull up here the affidavit. Oh. I have it. Well, the version I have is not a version I like. It's not it's a 5-page thing. I'm gonna end up spending all night on this. I know this. I'm feeling like this is gonna be an all-night thing. Supplemental report is not the right report. That's not what we're looking at. Supplemental report was after the fact, right? Yeah, that was after the fact. Where was it? This is 1 of 5. This is 2 of 5. What is this? All right. One second. I want to make sure I have everything here so we can actually have proper assessment. All right, here we go. 1, 2, 3, 4. This is not the way to do this properly, but it is where we are. Start page, case background. On May 16th, Nestor received a report regarding possible child neglect and controlled substance use. The report indicated, sorry about that. Nicholas was born 1981. It was reported Nicholas, social media blogger, and he and his wife Kayla had befriended hosts from a different local social media blogger. Those individuals were Aaron and April. You're asking that the cop knows personally these are personalities that steal to a morning show, which used to be St. Cloud, Minnesota radio. However, as of recent years, the show has been a social media entertainment, strictly online based. It was reported that the Imholtz may have been staying with the Rekietas and the home was in disarray and cluttered. It was reported from a church preschool teacher that his children had complained of being hungry and not fed, wearing the same clothes, and started smell. Nicholas was reported for being lethargic and on apparent higher drug, driving a car around. Another individual advised the reported that Nicholas will walk out randomly during sermons. It was alleged Kayla looks anorexic. Nicholas lost weight. One individual said that he having injection or track marks on his arms. The reporter reiterated concerns of possible neglect. I'm not trying to be a bad person and rat my neighbors. I'm just worried about neglect. Your affiant started to review the Rekieta and Imholtz's social media blogs. The blogs are commonly related to legal issues and high-profile trials, as Nicholas is a licensed attorney. He's known to drink alcoholic beverage excessively on these blogs. I immediately noticed that Nick's appearance in recent months had changed. Videos from January 2024 compared to May, Nicholas appears to have lost weight, appears tired, and overall seems strung out, common with controlled substance users. Okay. Nicholas commonly refers to his studio as his basement in his own residence. He's been the victim of swatting phone calls and known to me from these swatting phone calls. While reviewing Imholtz's social media video blogs, Aaron recently indicated that he and April are getting divorced. Aaron goes on to say that he experimented with cocaine 3 times. So he admits that he used coke and Molly 6 or 7. On December 19, 2023, the Imholtz broadcast a podcast from Rekieta's studio called Live from Spicer. Throughout Imholtz's video blogs, it's apparent that they and the Rekieta's friends were friends and may have recently had a falling out. See, they and the Rekietas are friends and may have recently had a falling out. Okay? It should be noted that in the recent videos, the Imholtz April has at times appeared tired, lethargic, and strung out. So I don't know. What do you do with this language here? What do you guys take this for? Tell me what you think. I don't know. What does this mean? We're friends and may have recently had a falling out. Not that they did have a falling out. They may have recently had a falling out. All right. In both Nicholas and Imholtz video blogs, it's also apparent that they're in the same room. All right. Let's get to the main video. On May 22nd, 2024, Imholtz did a video blog where he talked about Nicholas and insinuated controlled substance use and also referenced the video blog that Nicholas put online on May 21st, 2024. had since been taken off the internet, which was actually not off the internet but made private. But as far as the cop knew, it was off the internet. Imholt indicates in this blog that Nicholas needs help. He needs to get help for his kids because of his substance abuse. Imholt points out at a time in the video where Nicholas has a white powdery substance on his nose. So if you know that this, let's assume that Imholt despises Nick. If you put this in here and say these are all things that Imholt said about him, I don't know that we have anything here that's significant. Certainly before May 21st, I don't think there's enough here for probable cause. I think most people would agree with that. CPS agree with that with respect to the kids. So we definitely don't get to. I think everyone would agree we don't get the probable cause before that May 21st video. On May 22nd, your affiant was able to review the video that was taken off of Nicholas' YouTube and Rumble social media sites. The video is from 5/21/2024. Where did you review it? Where did he review this? The video is from 5/21/2024. It's of Nicholas in his basement studio talking about a Court of Appeals ruling he lost. He appears in the video to be drinking alcohol and eventually appears under the influence of a substance or substances. The entire video blog is 4 hours and 4 minutes long, approximately 2. And this is a typo here because it doesn't mean 2 minutes and 46 seconds. It means 2 hours and 46 minutes into the video. Nicholas leaves to go use the restroom. When he returns at 2:50, he appears to be making an excited look and has white powdery substance on his nose. Your affiant believes his behavior is indicative of central nervous system stimulants. Your affiant believes, based on training experience as well as behavior of Nicholas, that he ingested this white powdery substance through his nasal cavity while off camera. So now the question is, where did he see this? We don't know what he saw. He doesn't say where he saw it. We look at this here. He says, on May 22nd, I reviewed a video that was taken off of Nicholas's YouTube and Rumble social media sites. Where did you review that? It sounds like he's looking at the original. This does not sound like it's in any way doctored. So I don't think he admits that. If I read this, I'd be like, oh, okay, you got a hold of the video. Am I wrong about that? Does anyone think I'm wrong about that? Let me know if you think I'm wrong. I'm curious. Joe, Nick had a hearing about a couple weeks ago, and the cop had to admit that he did not see the original video. So, but over here, the point is, what information is the cop giving the court at the time that the cop is making the assessment? At the time the court is making its assessment of whether we have probable cause here or not, what information was the cop giving them? So, and it's not a matter of whether, the point is this: if you're a judge, would that be a significant thing? Oh, I thought you saw the original. Wait, you saw some duplicate, which may have been different. You don't know if it was different. You didn't even tell me that it was different. It was not the original. If the cop had come out, this is the point I want to make to you. If the cop had said in this affidavit, I saw a copy of the video he produced on May 21st. Based on my review, I believe that it was not altered in any material way. And this is what I saw. Well, now you have a judge who is actually informed, making a decision that is informed. The judge might say, oh, okay, I trust the cop's assessment on that. Or I don't trust the cop's assessment on that. The point is, we should all be looking for the police to be held to a standard that they're going to be telling the court with candor what information they have and what the source of that information is. And when they write something like, I was able to review the video, it was taken off of his channel, and not tell you that it's something that it's not, that it does look different, it was not the original, it does look different than what he saw, and the judge has no way of knowing that, I don't know if he got it from Aaron Imholt. Maybe he got it from Aaron Imholt. Maybe he got it from some other channel that hates him. Those videos were going all around. Maybe he got it from a different channel. I don't know. I don't know if it was doctored or not. And I'm not saying I believe it was doctored. If you ask me my opinion, I'm telling you right now, I don't think it was doctored in a material way. I don't. The point is whether or not the judge is being given something that the judge is reaching an assessment of their own. It's not my call about whether or not to issue the warrant. Right? That's not up to me. The question is, did you give this judge proper? Is the information you gave the judge so consequentially flawed or have it filled with omissions that they were not able to make a genuinely informed decision about probable cause? That's really what it is. Yeah, that's the thing also. They may have had a falling out. That's very much, I thought you said they had a falling out. They say they may have. It actually implies that the Imholts, April and Aaron, had a falling out with the Rekietas. I don't even know what the hell is happening here in this affidavit. It's a little weird. The cops have to report about no medical conditions, and they know them in warrant applications like narcolepsy. We have no way of knowing that he knows anything about Nick's narcolepsy. So I don't know. I don't know the answer to that. Nick has stated multiple times that extremists present a hyperbolic version of the most interesting characteristics, i.e. an act. How can this be PC? Probable cause. We watched Aaron's stream and Aaron was playing the video. That's what I thought happened. How do you know that? How would he know that Aaron didn't make Nick look worse for the purpose of, hey, let's all laugh at my enemy? How does anyone know that? And I don't know what Aaron shared. I doubt he did. I doubt he's sufficiently technically efficient or technically aware. I wouldn't be able to doctor it to make it look like, if I wanted to make some rival of mine look like drunk or coked out, I wouldn't be able to play with video to make him look that way. I have no reason to assume that Aaron has that knowledge either. I'm simply saying, how does the cop know he doesn't or didn't? I don't know any this is, or at least tell the judge, hey, where'd you see it? Where did you find this? Anyway. Let's go back to Kurt here.
And so forth and so on. We want to get back to the primary material to the best extent possible. That's the best evidence. It's going to be the primary original, right? So, yeah, but for the purposes of a probable cause,
Palmyra Production says, crap, this sounds like me after a week of working with 60 plus content creators who think they know everything, and I don't do any of that crap, so the cop speculations should not warrant a warrant. But cop speculations never should. You have to sort of say what facts you're seeing that warrant a warrant. That's the point, is that you're supposed to say, this is the information I have. In my estimation, this leads me to conclude X. And tell them how you reach that conclusion. The point is, but then not to sort of sugarcoat what you have and bolster it by implying that it's coming from a reliable source.
So the video itself is not reliable. And the problem is that deputy didn't identify to the judge. It's my belief that if Judge Fisher had known the allegations were made and being evaluated and dismissed, and the video was not, that Deputy Pomplin reviewed was not Mr. Rekieta's video, but was in fact a video that someone else had copied and had elements to, like the watermark, that she would not have issued the warrant, at least
not the point that it's the watermark. The point is it's not the original, and the judge doesn't know it's not the original, and you don't know what video he saw. At least he should say, he should be forced to tell them that I think it's materially the same as to what he produced that night. He didn't even say that. He just said, oh yeah, it's the right video. That's what he said. He said, I had a chance to review it. He never has. To this day, he never has.
In the 4 minutes from the moment she signed it and then signed the warrant. 4 minutes elapsed between the application and the warrant. Well, be that as it may, judges often rubber stamp warrants, as you might expect. So, yeah. I assume that all judicial officers take their responsibility.
Well, if they rubber stamp warrants, then why not give full disclosure? If they actually really rubber stamp them, well, then just say, hey, look, I don't know how many times this thing was edited, but this is what I saw, and I think it's there, and they'll just rubber stamp it. Clearly, the cop didn't think it was going to be rubber stamped. The cop was worried about reaching it. Otherwise, the cop would have given more disclosure, you would think, right? I think that makes sense.
Jobs and responsibilities seriously. And in doing so, they rely on officers of the law to be honest and fully forthright. And
Question: if they knew about his narcolepsy, would be something that would be for his Frank's hearing? They have full access to all his YouTube videos. Why would they only review the one? Well, he implied he's been watching him for a long time, although we don't have no idea how many hours of Nick Rekieta he's actually surveyed. So I don't know. But I don't really see that playing into the Frank's hearing, because having narcolepsy, you're saying that's going to imply that's why he was acting the way he was acting that night? See, here's the thing. It's very hard for us to divorce ourselves from what we know versus what the judge knows versus what the Constitution says versus how we feel about someone. And that's why all this sort of gets glommed together. And it's an attorney's duty or the judge's duty to sort of try and compartmentalize each of those things. Meaning what I know about Nick or what I saw of Nick and whether I think that video I saw of him, which I don't know if I saw the same video you saw, but likely it was pretty much the same from that fateful night. You know, do I think that had been doctored? In my estimation, no, it hadn't been doctored. But it wasn't an original. So if someone came to me and said, hey, here's a clip I got, and it's being shared on this channel over here, not Nick's channel, of Nick Rekieta, you know, I'll come to my own assessment. Do I think this was doctored or not? And if someone says, I saw this, and trust me, it wasn't doctored, in my estimation, it wasn't doctored, I might be like, oh, okay, fine. I trust you on that you don't think it was materially doctored. The point is, I should at least know whether or not you saw the original, right? I mean, I don't think that's an unreasonable thing. Cops got the vid from COG. It's in papers, not doctored. Again, wait, from COG? What's COG? You don't need to send a super chat. Just tell me, what's COG? I'm looking for you, Foley. What is COG? Write out what COG is. Or if any of you know what COG is. That's a streamer? He's a streamer on YouTube? I don't know. Does that make it? I don't think. Wait. It's a channel? Again, if you ask me my opinion, the video I saw, I can understand someone seeing that and saying he looks like he's coked up. He looks like he's on something there. Video that I saw. Someone showed me someone like that, and you ask me my opinion, looking at someone in the video who looked like that, I think to myself, that person looks like there's something happening there. I don't mean that. A lot of people thought that it was sexual, and I didn't take it like that at all. I took it as, yeah, he to me, it looked like he was doing an imitation of Dave Chappelle's coked up character. What's the guy's name? The guy who always has, like, you know, crack all over his face. That's what it looked like he was. I mean, he looked terrible. He did. I was horrified to see that. I was. Now the question is, does that come to probable cause? And maybe a judge would say that is probable cause. Maybe they would. I know Robert Barnes would say that's not probable cause. But at the very least, the judge should know, hey, it's not the original that I'm seeing. And maybe the judge would be like, okay, but if you tell me that you thought it was, you know, not materially doctored and that the guy just looked coked out of his mind and that you think of probable cause, you know, maybe a judge would come to that conclusion, and that I could see that withstanding scrutiny from Minnesota's Supreme Court. But not having the accurate information is the problem. The fact that the cop is hiding the accurate information, so now the judge is not equipped and armed with that knowledge because then we don't know what they would have done in that scenario. Yeah, when we're trying to figure out probable cause justifications, what they find or don't find, and this is something that Kurt's going to mention in this video also, what they find or don't find does not retroactively make the warrant good or bad. If they went in there and found no coke, that would not make the warrant illegal. And if they go in there illegally and then find coke and get lucky that there's coke there, that doesn't make it a legal warrant. And it's very hard for us as humans to actually get behind that, but that's how we sort of, from a legal perspective, have to approach it. My Rumble people trying to get my attention. Dr. Jenks says Cog is a jobless British retard who streams to like 20 people. All right. I don't see him trying to get my attention. I just looked in here like 3 minutes ago. I don't know what's happening. All right. Let's go forward.
Fully forthcoming in their expressions to the court. I think in this case, there are material omissions that Deputy Pomplin did not tell Judge Fisher about, which renders the warrant invalid. I don't think so, but okay. One of the other issues that I raised was the fact of the warrant. If the warrant is valid as to drugs, the police seize firearms, or alleged firearms, I should say. Lol. We're not even sure whether or not they're firearms or not. I appreciate that. From Mr. Rekieta's residence. Those firearms are not listed in the warrant. There's no indication they were looking for firearms. The case law I cited in the brief, and I won't go over it here, is pretty clear that even with something in plain view, it has to be related substantially to, or there has to be a nexus behavior between the alleged offense for which the search warrant was granted and the seizure of the item not listed on there. There's no.
So this is interesting because could be a unique quirk which would take us out of the Horton versus California scenario and be unique perhaps to Minnesota, where plain view doesn't help get you around the lack of a warrant in Minnesota. Meaning I agreed with Kurt and Uncivil that Horton seems to give an exception for plain view, that if you get a warrant to go in for crime A and now in plain view you were to find, the case I gave them was this. I said, imagine you have a warrant to search for drugs. Okay. You go in, you secure the place. Whole place is safe. There's got 50 cops running around there. Anyone who's in the room there is all handcuffed there. You go in there and you see on a big screen here, the size of a wall. You're looking for drugs. And you go into the main offender's office and you see on the screen there, in plain view, projected on the screen, coming from his computer, a thing that says, this is how we conducted tax fraud over the last year. And it's a whole flow chart explaining how they conducted tax fraud. Now you want to seize the computer. Why do you want to seize the computer? Because you want to establish tax fraud. Does your warrant give you a license for tax fraud? No. But you figure, hey, there's a lot of evidence of tax fraud in this computer. That's a crime. I want to go after them for the tax fraud. Do you have to get a warrant or not? Are you required? Because the warrant only gives you the right to search and seize things related to crime A. This is very clearly not crime A. Are you allowed to seize this without getting a warrant? Now, under Horton, they say plain view exception, you're allowed to do that. Does that mean that applies in Minnesota? Not necessarily. Minnesota might have a higher yardstick for police officers. I don't know. And it seems as if over here, the attorney White believes that the broad rule of Horton doesn't apply in Minnesota. I don't know.
No nexus here. There's not substantially related, and there is no nexus here. The case law is pretty clear. The third issue that I raised involves Miss Imholte's statement to the officers after she's Mirandized. There's a lot of confusion about this. I would think so, because it didn't make any sense.
All right. So I don't want to spend a lot of time talking about the whole April Imholte element to his omnibus motion, because I'm going to tell you right now, his lawyer ends up admitting that all the stuff related to April is not really timely now. It's not really ripe now. The reason the lawyer brought it up now was because they want to put the state on notice about this issue. And what they end up explaining, and I'm going to skip past much of this part here. Well, he does a pretty good job breaking down. Let me let him break this down here as to like the way the lawyer brought the argument and why Kurt had an issue with it, and I think properly so.
Which is what that section talked about. Okay, the motion itself was styled, that is titled. Okay, the motion from Nick was styled, that is to say titled, as partially a motion to suppress, a motion to dismiss, and a motion to suppress. That was how it was titled. That was how it was styled. Okay.
Which is a weird thing, because if you're dismissing it, then I guess in the alternative, if it's not dismissed, then suppress. Okay.
And then they get to, okay, the statements from April should not be admitted to against defendant. All right. And then for like 3 paragraphs straight, they talk about Miranda and the failure relating to Miranda and the fact that the police apparently or allegedly violated April's Miranda. Okay. That's an issue relating to suppression. That's an issue relating to suppression, right? The statements were obtained in violation of Miranda. You can't use them. They need to be suppressed, which is how the motion is styled. Okay.
So let's understand this. And this is what, I mean, he doesn't even break it down like this. Search and seizure is a 4th Amendment issue. Miranda is a 5th Amendment issue. And then Nick's lawyer ends up coming up and saying this confrontation clause issue, which is a 6th Amendment issue. So we're sort of going from a motion that's dealing with 4th Amendment issues, jumping into the April Imholte thing, talking about her Miranda rights, which is 5th Amendment, and saying that allowing you to put her statements in without her testifying would violate Nick's 6th Amendment rights. It is sort of discombobulated.
In the very last sentence of that section, they start talking about the right of confrontation, which doesn't make really any sense. Okay, the issue dealing with confrontation is a different constitutional right. The issue relating to Miranda relates to your right to remain silent, which is your 5th Amendment right. The issue of confrontation relates to your ability to see them and hear from them in trial, which is a 6th Amendment right. So they're different constitutional rights. Also, it doesn't make any sense to bring up a motion to suppress in a motion to dismiss because they're different things. You would bring it up in a motion in limine, but it wasn't styled as a motion in limine. It was styled as a motion to dismiss and a motion to suppress. So, and then they start talking about Miranda, and I'm like, oh, I'm interpreting this as a motion to suppress because that's how it's styled, and it doesn't make any sense. So if the issue was suppression, or I apologize, if the issue was the right of confrontation, it was very poorly written to that effect. It was very poorly written as a motion to prevent confrontation or a motion to exclude relating to trial, which I don't think we're necessarily near, and confrontation. But as far as it goes in sort of the right to confront, then sure. I mean, it's hearsay. Of course, if the statement from April implicates Nick and it's being offered for the truth of the matter asserted, then it's hearsay.
And Kurt's completely right about this. You don't need to get into the whole confrontation thing. And in fact, the state is going to end up admitting this, saying, why are you getting into this whole confrontation thing? We won't bring her, if we don't bring her up here, if we don't bring her on the stand, we cannot introduce her statements because if we tried introducing it, it would be hearsay. So in that sense, and what Nick's attorney ends up saying, and I'm not going to go through the whole hour-long thing here because I think that there's some back and forth that happens here, which is really not necessary for breaking down here an understanding as to the motion. Back and forth is, with respect to, I mean, the court over here, I'm going to skip forward where the court actually starts agreeing with what Kurt's saying.
I just say the motion in limine. Executed. The statements hadn't happened yet. So it doesn't make sense because that's how time works. Oh, man. Jeez. The court, I'm going to stop you there. That third issue, though, isn't it more of a motion in limine? See, that's literally what I just said. Didn't I just say the motion's motion in limine? It's nice when I get there first, right? As part of my little rant, didn't I say this makes much more sense as a motion in limine rather than a motion to suppress? Really didn't I literally use the words motion in limine?
Yeah.
I did literally use the words motion in limine.
Motion in limine would relate to like a motion that would come up with respect to how the trial is being conducted. So he's like, we're not anywhere near a trial right now. If they decide to bring her up, in that case, at that point. And now
the court is using the words motion in limine.
And what his lawyer makes a fair point. Nick's lawyer makes a fair point. And I'm going to skip past him, like, you know, him being very excited about how accurate he was, because he was spot on. I get that feeling, but I'm a little pressed for time here because I'm already 2.5 hours in. But Nick's lawyer ends up admitting that it is premature, but I didn't want there to be an issue that didn't give sufficient notice.
The judge is just saying exactly what I just said just now. It's like it's always validating. It's always validating as a legal analyst when you say something and then like the very next thing the court says is what you just said.
It is.
It always makes you feel a little bit smarter.
Yep.
It's like I literally just said this, and now the court is just saying exactly what I just said. It almost exactly the same words.
Your audience
it validates me.
Told you.
I appreciate it. I'm not sure if it's proper for me to discuss an admissibility or an omnibus, discuss admissibility since it's not a constitutional or legal issue. It seems like more of a motion on limine is what you're suggesting on the last issue. Okay. That was my initial thought, Your Honor. But the case I cited, Souter, seems to end up with the issue being harmless error because, again, this is something I'm drawing from my research. It doesn't state explicitly because it wasn't raised early enough. So belt and suspenders, I want to make sure that's raised as early as possible. Okay, fair enough. So he's concerned about the issue being preserved, so he wants to raise the issue as soon as possible. Fine, I appreciate that. Feels premature, but fine. And the state has conceded, and I'm sure Ms. Pierce will tell you, that they will not use the body cam footage that I'm asking the court to preclude unless Ms. April Imholte testifies. With respect to her statements as it relates to Nick, then sure, they wouldn't use that portion of it because, again, that would be offered for the truth of the matter statements. It's a statement from a different person, and you wouldn't be able to use that. So that makes sense. That would have to be excluded. I get that. Okay, thank you, Your Honor. All right. So summing up your first issue, then, you're essentially asking for Frank's evidentiary hearing. And you mentioned some items you placed in the MNDES. Just one moment as I refer to those. That was, well, do you detail what the exhibits are? It looks like you have some video recordings, the document image, a letter from Family Services, the application for a search warrant, and another video. Does that sound correct? There are in there. I'll get rid of the two easiest ones to get rid of because there are two body cam videos because Ms. Pierce is conceding that is not necessary, and those relate solely to the third issue I've raised. Those are not particularly relevant. The other video I have is a copy that personally downloaded of the Steel Toe Morning Show. Steel Toe Morning Show from May 22nd, 2024, because it was their morning show, not the evening show, because apparently there's an evening show as well. I downloaded that. And the video reference to the times are that in our motion. The application for the search warrant, of course, was to the court that already had that, but it was for ease of use. The letter is a letter that I referenced from Candido-Hyde County Human Health and Human Services, stating they investigated the report from May 16th, and they found it wanting for any evidence of child abuse or neglect, which is a pretty low standard. Yes, it is a pretty low standard. Again, probable cause is basically the standard. It is an exceptionally low standard. I agree. Candido-Hyde County, apparently Child Services, didn't find it in their investigation, which may or may not mean it legally.
Okay, so now I really want to see that letter from Child Health Services. Because if that letter says we did research of our own and see no neglect there, that's something that I would say they had to incorporate. Because that would help refute the claim that, hey, here's more evidence that they're doing drugs, the kids are being neglected. Well, they're not being neglected in the eyes of Child Protective Services. So, or Health and Human Services. So that's information that the judge would need in order to understand the totality of circumstances. And the cop keeping that away from them inhibits the judge to be able to properly assess totality of circumstances. And again, the same way we look at totality of circumstances as to, does this now, all the circumstances we see showing Nick to have committed a crime now gets us past probable cause? That's the way the law works. You would think totality of circumstances of all the terrible things that a cop does to mislead the court, we should look at the totality of those circumstances and not pick off and say, this one was harmless, and that one was harmless, and this one was harmless, and this one was harmless, and this one was harmless, and now we're going to just pretend that like 14 different harmless things are all nothing. When, you know, they might have affected a little bit, and then a little bit, a little bit, a little bit. You would think that totality of circumstances is a healthy way to look at those wrongs as well. To me, that's just logic. I don't know. To me, that seems like that's what if it was your kid who was the subject of a cop's affidavit. I think that, and you saw one thing, and then another thing, and then another thing, and another thing, and another thing. You might say, let's look at these in totality, right? I think that's how you would look at it. And if it was you, that's how you would look at it. You'd be like, look, this guy is ridiculously biased against me. The same way, you know, if you look at any one report from CNN, it's like, no, one of them tells you they're terrible. It's a no, we have a healthy body of work to assess and recognize they're awful. But it's not like this one story is the one that tells you that they're terrible. No, you just see another and another and another and another and another and another, and until you're finally like, I don't know what the hell they're talking about. I don't know what the hell they're talking about. And you can sort of write off and say, well, this one's no big deal. You know, you can understand how they came to that conclusion. And this one, maybe they were a little bit too generous to one side than the other. But when you see one after another, after another, after another, you look at the totality of circumstances. So I'm totally fine with totality of circumstances. That's what is indeed the law with respect to reaching probable cause. I think when we're looking at how the cop was misdirecting a judge, we shouldn't look at any one thing they did wrong, but look at the totality of circumstances and all the different information that the judge now has a whole different slant of this thing based on the totality of omissions from the cop. I think that's logical, and I think that's reasonable.
This, of course, because ultimately that's a decision for a judge, but they apparently didn't find it. Fine. The PowerPoint presentation is titled rekietavideo.pptx. That's a PowerPoint presentation that Deputy Pomplin references in Supplemental Report 1, which also included they created from someone else's stream, not from Mr. Rekieta's stream, but from someone else's stream. And the rekieta.png, that's a screenshot taken from the stream. Okay, and I already mentioned the supplemental report, and I think that's everything, Your Honor. What I'm saying is that the evidence is not the best evidence. That is a technical term. Best evidence. And he's right, it's not. Right, best evidence is a technical term. Best evidence means as close to the original as we're capable of getting. We want the original thing. That is the best evidence. We don't want to hear about it from a guy. We want to hear about it from you. We don't want to see a copy of the tape. We want to see the tape. We don't want to see a copy of the photo. We want to see the original, and so forth and so on. Assuming, of course, it's available. Assuming, of course, it's available, because maybe we don't have it. Maybe it's been lost along the way. In which case, the best evidence by definition is whatever we have left. So if all we have is a copy, then a copy will do. Of course, we'd have to disclose it's a copy so that the jury will know that.
So why not disclose to the judge if this was a copy? If he disclosed this was a copy, I'd be like, you got nothing here. You got nothing. But why didn't he disclose it was a copy? He just said, I reviewed it.
So they can factor that into the analysis. So we can't hide from them that it's a copy. But if it's the best evidence, then it's the best evidence. The best evidence is as close to the original as we happen to have. So yes, it is not the best evidence. I agree. As a technical term, it is not. But for the purposes of this motion, I'm not sure that it needs to be, because, you know, best evidence is kind of a rule that applies at trial, and that's, again, premature. It is not the original evidence.
Would the DA or ADA help draft the warrant? I don't know. I don't know about criminal procedure to even hazard a guess. I think cops are trained in how to draft it properly. Could be. Might depend on the case. Regarding child neglect, the kids were being seriously neglected. Why would CPS allowing them back with their parents? Well, it could be that now, you know, they look particularly clean. Maybe, like, you know, if you want to argue from the from the state's perspective, when they took him, he wasn't. Now he is. You know. I think it's hard to make an argument he's not clean now.
And the Judge Fisher, had an expectation she would have been informed of that. Deputy Pomplin did not inform her of that. In fact, his application indicates if he watched Mr. Rekieta's stream and seeing that was only suggestion there were drugs in the house, then she had a duty. She had a need to know, and he had a duty to tell her that had been edited so she could have evaluated that.
And I agree with that. I think he does. I think that they did have a duty to do that. I think that's a fair point that Nick's lawyer is making.
Yeah. All right, Mr. Pierce. Any objection to the?
You're saying, but it's like, okay, there's this thing, and then there's another thing the cop did, and there's another thing, and each time you're like, there's a little too ticky-tacky. There's a little. It's like, That's why I say I think the totality of wrongs is something that should be assessed.
Court receiving these items. Miss Pierce. Your Honor, I would object to the video of the Steel Toe Morning Show. The affidavit for the search warrant does indicate that they did review a video blog on 5/22/24 from Aaron Imholt, but there are, as Mr. Francis White says, there are multiples per day. I don't know if this is the one that was watched, and I can't speak to the authenticity of that video. All right, any further responses on that issue? Your Honor, we're not submitting it for the truth of the matter here. We're submitting it as an indication there was a different video than what was actually reviewed. But excuse me, that Detective Pomplin watched the show, and the show indicated that there was animosity between the two parties. If you grant us an evidentiary hearing, the Frank's evidentiary hearing, I'm certain we'll be asking Detective Pomplin whether he watched the video or not. So yes, a Frank's hearing would be ultimately where this would go, right? If the court finds there's enough evidence for a hearing.
And that's an important thing to understand. He's not looking to get dismissed right here and now. He's like, give us an evidentiary hearing, so then you can conclude that this needs to be dismissed, not this evidence, this warrant was wrongfully obtained.
As to explore this, then you might have testimony from some of these people on the stand as exploring whether or not this was proper or not. But, you know, Frank's hearings are very, very rare. They're very rare. And they usually relate to more serious problems than this. They would usually relate more to the cop have active knowledge that there were not drugs in the house, you know, because someone was in the house and like, I looked everywhere and there were no drugs, Your Honor, you know, that kind of thing. But this all seems this doesn't seem in the sense of being sufficiently concrete to warrant a Frank's hearing. You know, Frank's hearings typically rely more of an explicit or direct contradiction, you know, rather than, you know, it could have been phrased slightly better. So this seems a little bit weak, in my opinion, for a Frank's hearing, but, you know, okay, that's what they're asking for. All right, well, I'll take the...
And I'm going to pause here. In fact, I'm probably going to even wrap up over here with some final thoughts here, because I think that's, you know, I mean, the rest of there's really not much more.
Possibility of that under advisement. I'll review it and determine whether a court will overrule the state's objection. Ms. Pierce, Your Honor, would ask for to allow to do a written response. All right, how much time? If I could have till 30th, Your Honor, that'll be fine. August 30th. Okay, so the state is going to file a written response on this issue,
and then he's
to deal with it. So fine. So they have 3 more days to file their response, in which I'm sure they will kick, you know, their teeth in, or at least try to. So we will cover that, of course, whenever it comes in, and that will be fine. All right, let's see what else we got. And then it says, Mr. White, Your Honor, I'd ask to be reply to the written response. I have additional 5 days. Any objection? Typically, this is your motion. I'd have you file your submission first and the state's after. My submissions, Your Honor, are already filed. All right, in light of that, I'll allow a reply brief by September 6th. Okay, yeah, so they already filed their thing. The state wants to do a response and they want a reply. Okay, so that's fine. The state files on the 30th. They file their reply on the 6th. The court enters its decision at some point following that. So fine. All right. In light of that, I'll allow a reply brief by the 6th. Thank you, Your Honor. All right. The court will take the matter under advisement as of September 6th and issue an order. Typically, an order will be provided within 30 days of that date. So we may not have a decision on this issue until October. So, you know, fair enough, because sometimes they take time. Was there anything? I mean, this is normal, right? Things take time. They can be slow.
In New York, it would be 60 days.
And then, of course, the thing that would presumably issue at that is...
You hope. You hope. The CPLR tells judges to get it in 60 days. And if they fail to meet that 60 days, no one says a word, because you never want to tick off the judge. So you just hope they didn't forget about it.
Assuming that they were going to go next way, the thing that would be issued would be an order for a Frank's hearing. Would be the thing that would issue. The court would probably not be like dismiss it right out of hand, right? Because there's not evidence really to warrant that. So the best...
I started with news, but it was only like... It was less than 30 minutes of
that you're looking for is an order to have a Frank's hearing, which would be unusual. It would be unusual, so you wouldn't expect it. Typically in this, especially in this kind of fact pattern, because again, you don't really have the sort of massive contradiction that you might otherwise expect for. Was there anything else for your day? No, Your Honor, except for Ms. Pierce. Staying on the record, she did agree the third element would be, she agreed that there would be no use of the body cam footage unless April M. Holdy testifies. Ms. Pierce, I agreed there'd be, I cannot use April statements unless she testifies because they're hearsay. Didn't I say that?
You did. Correct.
Didn't I say that? It's like, yes, they're hearsay. They're a statement. They're a statement offered for the truth of the matter asserted. And Nick is not a party opponent with respect to the statements.
Yeah.
So yes, they're hearsay. So yes, it's like, yes. Again, it's nice when you get there first makes you feel better as a legal educator? It's like, yes, that's the correct answer. I cannot use April's statements unless she testifies because they're hearsay.
Frank's hearing is the hearing to determine whether or not the warrant was improperly issued, or there's a problem with the warrant which requires further action from the court, usually dealing with either dismissal or suppression of certain evidence. Comes from a case. I don't remember the name of the case, other than definitely called Frank's. I don't know if it's Frank's. I assume it's Frank's versus U.S. But yeah.
And would not show her statement on the body camera. I'm not agreeing I wouldn't use any of the body camera.
That's the yard.
All right. Well, nevertheless, these are motions in limine. You've noticed it. If there's an issue that does matter, it'll go to trial. If there's other further contest, we can discuss it further as well. So the judge basically says, this is not appropriate for this hearing, which is true. I agree. It's way premature. It's way premature. We don't know whether or not April will take the stand or not. It's premature for that. We don't know. So yeah. So the judge is like, okay, well, these are really motions in limine. And so you've noticed it. Cool. And if we ever get to scheduling this thing for a trial, then you can feel free to.
Okay, so his point is this that he made earlier, and I'm going to sort of try to start landing the plane here and giving my final thoughts on this. So Kurt comes to the conclusion saying this motion is a loser, and he ended up ticking off one thing after another. He's like, well, the CPS report, that's not necessary because the warrant wasn't really. First, he starts with a bar saying that probable cause is very low. I disagree with him on that assessment. And first you have hunch is really low. Second is reasonable suspicion, and then above reasonable suspicion is probable cause. In my estimation, I think probable cause is called probable cause, not possible cause. So, and probable meaning that probability tells us that a crime was committed. I think it actually means more likely than not that a crime was committed. I think it's very close to preponderance of evidence. It's a lower standard than a civil case preponderance of evidence because in order to reach that yardstick of probable cause, you can rely on evidence that would never be admissible in court, like hearsay or hearsay on top of hearsay. You can rely on all sorts of things that would never come in or not best evidence. And look at the totality of circumstances and say, okay, given this totality of circumstances, we're not sitting in a courtroom now. We're just a bunch of guys sitting around a bar having a conversation. Do you think he did it? That kind of thing. Do you think, yes or no, you think he did it? That people would come back and say there's a reasonable chance, it's a reasonable thing for someone to come back and say that maybe not everyone would say that he did it, but someone who would come out and say, yeah, he did the crime based on this that I've heard about, that's enough for me to say, issue a warrant. That a reasonable person, not an unreasonable person, I think the guy did the crime. And you'd be like, all right, I disagree with you, but that's a reasonable take based on what we know. Okay. Then you have probable cause. If not, then you don't. When you look at totality of circumstances and you look at a whole bunch of evidence, we never come in a civil trial where the yardstick is preponderance of evidence. So in that sense, I think it should be more likely than not that the guy did the crime in the estimation of, one person, or you think that folks would say, reasonable people would say this guy committed the crime or is about to commit a crime. That's where I think it is. So is it quite at 5? I don't know if it's quite at 5, but it's in that, it's not all the way down at 1, which is where Kurt refers to it being. I think it's much higher than that in order to validate the issuance of a warrant. So that was the first thing I took issue with. And one of the primary reasons why I wanted to review his stream here to give my personal legal assessment on. I think he makes some great points here, Kurt, with respect to, CPS, that letter from CPS. If the letter from CPS says, we saw what you're claiming of, yes, it's true, but that's still not enough for a warrant. A claim that the kids smell, or a claim that, that he looks tired, or he's walking out of church, this is not enough to give a warrant. That's not exonerating Nick. And if it's not exonerating Nick in any way, shape, or form, then it does not need to be included in the affidavit from the cop. But if it is exonerating, and you can incorporate it there to say, look, he's being neglectful of his kids. Why would someone be neglectful of their kids? Often it's because of drugs. So that comes into the totality of circumstances of we think that there's drug use going on here, there's active drug use going on here, because look, They're so drugged up they can't take care of their own kids. But if in fact that's not really a factual assessment, if the CPS is coming back and saying our legal assessment is this is not enough, then cop doesn't need to include it because it's not part of the whole factual totality of circumstances. But if they come back and they say, hey, we looked into this, those kids are being taken care of properly. And the cop's like, well, all these people complained that he's not being taken care of properly. And yeah, CPS told us that they looked into it and they are being taken care of properly, but we're not going to tell the judge about that. That to me is a very serious thing that they're leaving out. Because they're saying, here's a reason you should think that they're using drugs because the kids are not being taken care of, when in fact, the state itself came in there and said they are being taken care of. So really it comes down to the content of that letter as to whether or not, and if it's more of a legal conclusion, and if it's a legal conclusion and merely a legal conclusion, in that case, the letter can properly be omitted by the police officer. If there are factual conclusions, then I do not think it can properly be dismissed and left out of this affidavit. And the cops should be obligated to share that information with the judge to be like, yeah, there's nothing wrong with how the kid's being taken care of. The state went in there and looked at them and said they were fine. So I'm tossing that out. That's not part of the equation here anymore. But by the cop leaving out those factual assertions, assuming those factual assertions are in that letter, that is wrongfully tainting the totality of circumstances perspective of a judge, and potentially materially. And then we come down to this whole thing with, the concerns. The other element is concern citizen of Aaron Imholt. The language is they may have had a falling out. They may have had a falling out. If you watch the videos, they hated each other. They did not like each other. So I think that really is grossly underselling the level of animus there. Now, is that enough that would take out the whole thing here? No. But I do think that you can say, if we look at that, and then you have the whole thing that he misled the court and said, I reviewed the video. You didn't review the video. You reviewed a copy of the video, which had been somewhat altered, probably not in a material way. And you could have said that to the judge, and the judge would be like, oh, okay, I don't care. Likely would have said, oh, okay, I didn't care. But you left that out also. So you left out that element, and then you left out the whole thing about how your source here was a guy who hates Nick, and then you left out the fact that the state says, hey, his kids look totally fine. And you look at the whole totality of this, and you can start saying to yourself, what the hell's happening here? The judge had like a much, much darker picture of the Rekieta home at the time she issued the search warrant. And if she had a more accurate picture, it's very unlikely she would have come to the conclusion that there's probable cause here. She couldn't have reasonably come to that conclusion. So that's what Nick is hoping the court is going to come to that conclusion that, hey, let's have an evidentiary hearing. And in the evidentiary hearing, we'll see about just how misdirected the court was based on the affidavit from Officer Pomplin. And that the totality of his report is so skewed that the judge really was working with a whole different assessment of totality of circumstances than she should have been if she was more informed. Well, in that case, perhaps that they'll grant the dismissal. Do I think Nick will win on this motion? Because that's what everyone wants to know. Do I think he'll win? The answer is probably not. Probably not. Because it is hard to get a Frank's evidentiary hearing. Kurt is correct about that. It's hard. And there's no smoking gun. He's correct also in the fact that there's no smoking gun saying I can't believe you left this out of the affidavit. Imagine if you will, okay, that his source was something like Tony Montoya being spliced in to Nick Rekieta's studio, and that's the video that he watched. That's something that you'd be like, oh my God, you totally lied to the courts and said that this was Nick when everyone knew that it was just Tony Montoya and there was a joke video and you treated it as if this was something serious, and that's how you got in there. If that had actually happened, which I know is not what happened, but if something like that, if it's that level thing, then you can understand them saying, let's have an evidentiary hearing. And if in fact everything they're saying here, if that thing is Tony Montoya on there, I'm going to tell the state to go F itself. That's a smoking gun. Boom, bazooka. You don't have a bazooka here. Nick doesn't have any bazooka here. It's that, hey, you got this thing, this thing, this thing, this thing, and you might, and all of this affected the totality of circumstances. It's not a sexy thing for the court to latch onto and be like, yeah, that's the thing I want to focus in on. Remember when we were looking at the whole Fannie Willis situation? So in Fannie Willis, it's like the judge was zeroed in. This is what I care about here. This is what I care about. Like, was she wrongfully pocketing money from this thing? There was all sorts of allegations of wrongdoing by Fannie Willis, and she's giving speeches and prejudicing people and stuff like that. The court's like, I don't want to hear about that. Why? Because the judge zeroed in on one particular thing that really caught his attention, which I assume was not because of the lasciviousness of that particular scenario, or a sexual relationship between Fannie Willis and Nathan Wade, but that he thought that was the most egregious thing. That was the most egregious thing in his estimation, and that's why he honed in on that. One of the things that Steve Sado is pointing out there is like, you can't look at that in isolation. Look at all the different things that are happening here. In his recent motion that we went over the other day. Look at all the different wrongdoings by Fannie Willis. And similarly, I think that's what Nick's lawyer here is looking for as well. Look at all the different wrongdoings by Officer Pomplin. Look at all these different crazy things that he did. And, you might say this one individually didn't do anything and that one individually did anything, but you put them all together in a big package, you can understand how if that package was actually in the totality of circumstances doesn't come anywhere near probable cause. Will it work? Like I said, probably not. It probably won't work. You definitely take the shot. And Kurt concedes that you take the shot. It may work. It may work. But the chances are low. Chances of getting evidentiary hearing out of this are not great. They're not great. You take the shot. The other thing I'll point out that I think is important to understand is this. Even if they fail here, I think a large part of this is there's a strategic element towards getting the state to lock itself in on certain positions. Lock themselves in as to where they are on this, on that, on this, and on that. And by having them, the more locked in they are, that's what a motion like this does. It forces them to take a position. What did Pomplin see? What video did he review? Who told you, what did you know about Aaron Imholt? And this serves almost in a way, the reason we have depositions in discovery is because when you have discovery, you're locking the person into the position that you're testifying today under oath. And now this is what's memorialized, that you swore that this is the truth on this particular set of this issues that you're questioned about. And now when you question 6 months, a year later at trial about this, if you try changing your story, we can wave this deposition in your face and say you're full of crap. This is what you said a year ago, much closer in time to the when the events happened. This was your recollection at the deposition. Clearly, your recollection closer in time is better than your recollection is now when you're trying to change your story. So that's why we have discovery. Well, in this sense, this motion helps serve for Nick as a form of discovery, because it ends up strategically, even if you lose on the motion, you're forcing now Officer Pomplin to put in an affidavit in order to defend his warrant. Perhaps the judge will put in an affidavit. I doubt it. Unlikely. I'm going to scratch it. She's not. But this way you get the state to lock in, this is what we saw. Then you can take that story and try and show the flaws in that story. But if they're not locked in, then you can't start attacking them yet. So I think that's a potential benefit of this motion that people are ignoring. It's very possible for Nick to lose this motion and not win the war here and now, but set themselves up to be in better position to defeat the state down the road simply by locking the state in on certain positions in defense of this motion. So do I think they'll get the Franks hearing? My gut says no. It's possible, but my gut says no. It's much safer bet to say no. It's almost like saying, there's a 180 hitter coming to the plate right now. Do you think you want to bet on him getting a base hit? The pitcher's coming up to the plate. You want to bet on them getting a base hit? I'm gonna say no. I'm gonna bet against it. It's a safer bet. So it's a safer bet for me to say he's probably gonna lose. And he definitely doesn't have that killer thing that this is the thing that the state looks terrible for leaving out. And that's usually what you're going to need. And my argument about totality of circumstances, as nicely as I can frame it, well, doesn't mean the judge is going to swallow it. And if they don't, they're going to be like, nah, that's not enough here. There's not enough for us to have a whole evidentiary hearing. So that's my perspective. That is my perspective. Frank's hearing shouldn't be rare. It's just a test that the cops are honest. They don't. It seems like a great investment of the court's time. So they don't like doing that. Legal standards: some evidence, some credible evidence, reasonable indications, reasonable suspicion, reasonable to believe, probable cause, preponderance of the evidence, clear and convincing evidence beyond reasonable doubt. Nice. Well done. Some evidence, some credible evidence, reasonable indications, reasonable suspicion, reasonable to believe, probable cause, preponderance of evidence, clear and convincing evidence. That's a pretty healthy list there. Pretty healthy list. Well done. I'm gonna give you another one. One of those two. Well done, Elgin. That's increasing levels of hurdles. All right. That's my show, and I'm sticking to it. Please go to goodlogic.locals.com for all your excitement needs. No, not all. Definitely not all. Definitely. I don't know what word just came out of my mouth. Let me take that one back. All right. I'm gonna send you over to Nick. If he yells at you about how late it was, which he won't, but if he would, you just tell him I was. He gave me a project. What am I supposed to do? That's not supposed to happen like that. All right. I will see you all, God willing, tomorrow. Till then, if you're interested in the fantasy football league, goodlords.locals.com. I also had a vote for those people. If I put you on that list, you can send me the money. Send me the money. Start sending me the money. I don't know how to reach you people. I asked for a vote about like whether dates were okay, and I had 5 people voting, 7 people voting. I don't know if those dates are no good. If they're not good, please. If you sign off that it's not good, tell me what dates you need. Like, I don't know. Does that mean you're out of the league if I have to go with one of those 2 dates? I gotta know. Because I'm having concerns. I'm reaching deadlines here. So please, if you signed up and had an interest in the league, please make sure that you check notifications, keep me informed, and we'll try and set something up here so we can actually all get on the same page. I thank you all for joining. Don't touch no friggin' lab meat. No matter what the state tells you, don't eat the bugs. Have a good night and Godspeed.